Because of this cash amount, they have given 27A.
Yes, sir.
Financial traffic.
Recovered from the son.
It is undergoing trial at the moment.
Yes,
Margarita.
Four dates the prosecution took time to serve the
not.
copy.
Come.
Charge sheet was submitted on 23/6/2026. Cognizance was taken on 2/7/2026. But so on the last 4 days.
Because they have found a cash of 7 lakhs, that's why probably they have given this 27A.
And it is from the son, madam. Mother, because stays with the son, so he is aged about 69 years. Madam.
That has to be seen, whether he sees the stuff. Victim of circumstances or she's also involved. Mr. D.D. Quad, Learned Senior Counsel, assisted by E. Potakur. Call for the scan TCR of NDPS case number 29 of 2026. In bracket, Margarita PS 41 of 26. Under section 21B 27A of the NDPS Act, and which is stated to be pending before the learned additional special judge number 1 NDPS at Margarita. The petitioner was stated to be arrested on 1/5/2026. The case is stated to be at the stage of trial where the son of the present petitioner is also being prosecuted as a co-accused. Learned Senior Counsel points out that the quantities allegedly seized was intermediate quantity.
When in custody?
List on
16/9. 16.
16.
Yeah, obliged, sure.
16.
My lord, I'm sorry, I could not be on time because of the fact, my lord,
No, sure.
that our name is not reflected in the cause.
Oh,
That's why.
no.
But it's a motion.
Your special PP.
Scan copy of the.
Your special PP.
Yeah, my lord, absolutely. Assisted by him, my lord. Mr. Peter.
Yes,
This is the
ma'am.
motion day, my lord, so I'll pray, my lord, let the scan copy of the trial court records may kindly be called for. And
Yes,
a date will be
okay.
fixed. And our names may kindly be reflected there,
Surely,
my lord,
that
so
has to be.
anomaly doesn't arise.
This bail petition is filed by how many petitions?
By one Forest Bush, so my lord.
Only one petition. Third, your good name, please,
My lord S. Sharma.
and counsel for the petitioner, and Z. Kumar, Learned Senior Counsel and Special Public Prosecutor,
Assisted by.
assisted by for the respondent state. The invoking 483, section 483 BNSS, the petitioner, namely so-and-so, is seeking regular bail in connection with sessions case number 256 of 2025 under so-and-so section of BNS, arising out of CID police case number 18 of 2025, and which is pending at the stage of trial, right?
My lord.
For the exclusive fast track sessions court, Kamrup Metro. Petitioner is stated to have been arrested on 10/10/2025 and presently in judicial custody. What is the stage of the trial?
My lord,
Progress.
105 witness, 10 has been completed, my lord.
Already,
Yes,
110 witnesses. So, how many are there in the charge?
My lord, in total 394, but we have gone down to 250. So likely another 100 plus.
The Learned Senior Counsel submits that, and Learned Special Public Prosecutor submits that 394 witnesses are listed in the charge sheet. And so far, 110 witnesses have already been examined. Good progress.
My lord, trying the best.
Call for the scan TCR of sessions case number so and so, comprising, but the charge sheet case there will be very voluminous, right? It will
Case
be.
diary, we can produce it. Nowadays, under the BNS, my lord, case diary is not deposited in the court. It is.
Yes, true.
conducted, your lordship.
But
So
can
we'll
you
produce it.
produce it physically or
produce
we have to
it directly,
electronic
my
copy? Okay.
Yeah.
Case diary, charge sheet, and charge sheet will be very
No, my
voluminous
charge sheet will be definitely with the court, my
with
lord.
the court.
We will have the copy, of course.
Okay.
Probably they've annexed it also.
And
charge sheet.
TCR comprising case diary, charge sheet, and other relevant documents. We get the depositions also. Scan copy of the depositions also. Okay. Once you scan it, actually, it will be there. Whenever you need it, you can get it.
Yes, yes, yes.
Once it has to be scanned in any
Yes.
case, because
Probably
somewhere,
they can send it.
someone or the other will require it.
Yes.
So
sure.
you have to scan it. Because I was saying that if it is too voluminous, then we can see
No, it is
scan
otherwise
copy also.
voluminous
But the
because
scan copy has to be
Yeah.
searchable,
because the
searchable
charge sheet
PDF.
runs into 7 or 8
Yes.
version. 7
It
version.
has to be searchable PDF,
Yeah.
especially important in this kind of cases, searchable PDF.
Because
Otherwise, you'll get
completely
lost.
all the
See, even if it's electronic, you'll get lost.
Absolutely fine.
Okay. So list on,
But any
Take
date
it.
on the second week of
you take a date by your convenience.
March. Let's say, any date from 16, 15, 16.
How about 18th?
My lord.
Only one direction may kindly be given because so that no inconvenience is caused to the landed PP Assam also. My lord, our name as you
Oh,
spoke and special PP.
Yes. The name of the land senior counsel and special public prosecutor conducting the prosecution in this
Special
proceeding,
PP.
and may be reflected in the cause list as special public prosecutor. That would do. So senior counsel and special people shall be reflected in the cause list.
Much more.
One humble request, my friend, like assisted by Miss G. Borua.
Sure.
Obliged.
May I please, Your Lordship? Anticipated bail application, Lordship. FIR, Lordship, the vernacular is in page number 11. Okay, may I read it out? মই হেমকেশ্বৰ নাথ 34 বছৰ পীড়া প্ৰদীপ নাথ গাঁও মেধিপাৰা মাছপাৰা থানা মাটিয়া জিলা গোৱালপাৰা অসমৰ বাসিন্দা মই বৰ্তমান পলাকবাৰী কৰ্মসূত্ৰে পলাকবাৰীত থাকোঁ এই মৰ্মে জনাওঁ যে আজি 13/8/2026 তাৰিখে পুৱা 8:30 বজাৰ পৰা 9 বজাৰ ভিতৰত মই কৰ্মসূত্ৰে পলাকবাৰীত থকাৰ সময়ত মোৰ পত্নী আমাৰ ঘৰৰ আন এটা কোঠাত উপস্থিত আছিল উক্ত সময়ছোৱাত ৰাজীৱ নাথ পিতা ৰোহিত চন্দ্ৰ নাথ গাঁও মাছপাৰা মেধিপাৰা থানা মাটিয়া জিলা গোৱালপাৰা নামৰ ব্যক্তিজনে মোৰ অনুমতি অবিহনে মোৰ ঘৰত অনাধিকাৰভাৱে প্ৰৱেশ কৰি ঘৰৰ ভিতৰত থকা নগদ 80,000 টকা চুৰ কৰি লৈ যায় উক্ত ধনখিনি মই মোৰ ঘৰ নিৰ্মাণৰ বাবে সাঁচি ৰাখিছিলোঁ ইয়াৰ উপৰি মোৰ মাতৃৰ এযোৰ কাণফুলি আৰু এটা সোণৰ চেইনো ঘৰৰ পৰা চুৰি হোৱা বুলি জানিব পাৰিছো উক্ত ঘটনাৰ সৈতে ওপৰত উল্লেখ কৰা ৰাজীৱ নাথ জড়িত থকা বুলি মোৰ সন্দেহ হৈছে Lordship, this is completely concocted allegation, the false FIR. The informant is the uncle and the petitioner is the nephew, Lordship. I have stated in the para 5 of my petition, the actual fact, Lordship.
Just a minute. Just a minute. So while his aunt was in the another room, he is alleged to have stolen. Anyway.
It is alleged that, and he said he's also stated that he was not there at the time of occurrence of the incident. And
Yeah, okay. You wanted to show para?
Para 5, Lordship.
Yes.
And that the petitioner beg to state that the informant is his uncle and he is the nephew in relationship. There is a dispute going on over construction of house by the petitioner over the land of one of his uncle, namely Sosodor Nath, who died and was an unmarried person. After his death, the petitioner has constructed a house over the share of the land of his deceased uncle. The informant, who is one of the brothers of the late Sosodor Das, objected to this construction as was claiming that land. Due to such dispute, the informant has lost the instant as on the false allegation of theft upon the petitioner. Lordship. In fact, Lordship, the informant himself stated in the FIR that he was not there and his wife is also in another room and he has, this present petitioner has entered into his house without their knowledge and has taken away this. Lordship, I am ready to cooperate with the investigation at any condition, Lordship, I may be imposed upon me. I am ready to cooperate with the investigation and I may be protected. As the entire allegations are false, Lordship. In fact, no such incidents ever happened there.
Mr. Handik,
KK Hendik.
yes, please. Anything from your side?
Did you reveal the true fact?
Let him go record his statement because it might be appears to be a family dispute. Land Council, for the invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with Matia PS 85 of P6. So and so section. The allegation in the affair is that on 13/8/26 in the morning, while the informant's wife was in another room of the house and he was outstation, the present petitioner entered their house and stole rupees 80,000. And later some gold ornaments were also stated to be missing. Full stop. He has submitted that the petitioner is the nephew of the informant, drawing attention to para 5 of the bail petition. Mr. Handik, learned counsel submits that there is a dispute going on between the parties over construction of a house by the petitioner over the land of one of his deceased uncle who died a bachelor. So this construction was objected to by one of the brothers of his late uncle. Full stop. Pursuant thereof, it is further stated that pursuant thereof, the informant has lodged this FIR with false allegations of theft. The petitioner expresses his willingness to render his cooperation to the investigation. Call for the case diary. However, in the interim, 20,000 with one security will cooperate and appear before the higher for making himself available for examination. Shall not threaten or harm the informant and his family members. List on longest date
23/9/1.
23.
May it please your lords. In this case, what happened, affair is not registered nor filed as per the information received by the petitioner. Even then, what happened, the police person from the police station has called the petitioner twice for his appearance. Subsequently, the petitioner has come to know that the one Kashim Ali, with whom the petitioner had an agreement in relation to a flat, my lord, he obtained some loan from GIC Finance, my lord. Then the finance authority has insisted the police personnel to recover the said amount by pushing some pressure on them, by giving threatening of him their arrest, my lord. Accordingly, the petitioner apprehends that the moment he appears into the police station, my lord, he may be arrested in relation to the recovery of that particular loan amount, which is civil in nature, my lord. Apparently a civil case, my lord. If there is any such allegation, my lord.
Only a report may be called for,
Report
because he is the purchaser and the
protected.
parent.
I will
It
appear
seems
to the
that he is the builder of the builder, and maybe after taking money, probably he has not made any construction.
so far, petitioner party is concerned, my lord. He is ready to cooperate with the police station, any investigation or any case, my lord. He is ready to cooperate with us. His role is only
So he is apprehending that Kasim Ali might file a.
Hashim Ali has taken loan from the housing. So
The,
far,
the prospective informant is the Kasim Ali.
no, my lord.
No.
He
He is
the probably
sold the
the purchaser of the flat.
Dipjyoti Bora is apprehending arrest.
Yes.
so far
I will get a report, whether any case registered or not.
Okay, please.
meanwhile, I may be protected.
At this stage,
Because what happened,
Maintain
if I
protection.
appear, or so far the allegation is concerned, there is no such allegation as I have received against me.
FIR register, let me first get the instruction, whether any FIR in case register. If any FIR registered, I will produce the CD.
Giving protection, that will not hamper any process of investigation.
The petitioner Dipjyoti Bora has filed this application under 482 BNSS, seeking anticipatory bail, though he does not have details of any case registered against him in the This will be Gorchuk Police Station.
Police, Phaltan Bazar Police.
It is submitted that there might have been a dispute regarding construction of apartment with one, construction and sale of one apartment with one,
My
with Kasim Ali.
no. So for the allegation, it is not related to construction, my lord. Allegation against my lord Kasim Ali by the JSC Insurance Authority. So for taking loan, my lord.
I see.
There is no allegation against me, my lord.
It is submitted, it is stated and submitted that with regard to one person named Kasim Ali, there was an allegation with regard to taking of a loan under the GIC Housing Finance Gauhati branch, full stop. The petitioner apprehends that in connection with any such dispute to which the petitioner is not connected, he might be falsely roped in as well, and therefore he is before this court. Full stop. The prosecution shall get a report from the concerned police station about filing of any FIR with regard to the present petitioner as well, and registration of any case thereof. Stop. Till the returnable date, the petitioner may not be subjected to any coercive action with regard to any such complaint with regard to him. Actually vague, but
Right.
since you are desiring, so
Yeah.
I'm passing. Otherwise, we are groping in the dark, basically.
Otherwise, while filing, my lord, this, he knows everything about the case, what he has done, my lord.
So list on you, then you take a week since this protection has been given. Take a week,
Yes.
Seven?
next week. On, my lord, 3rd of September.
7.
7.
Don't fix too many
7
matters,
days.
2/3, because only 2 days, you'll not be
7th
able
of
to
September.
manage. 7. 7, no.
Till then I may be protected.
Yes, I've given.
Yes.
That is why I'm giving
Fine.
1 week.
Alia, brother.
Item 10.
Yeah, please, your lordship.
Just
For
points.
82 application, lordship, what happened, lordship? Two group of people which are known as the lessees of Silonibari Daily Market. They indulge in a class, my lord, and lordship, some persons are injured. Here, lordship may directly come to page number 17. The first para speaks itself everything, lordship. May I read, lordship? অভিনয় নিবেদন এই যে এজাহাৰকাৰীগণ চিলনীবাৰী দৈনিক বজাৰৰ বৰ্তমান মহলদাৰ হওঁ there are 4 persons named as a complainant. ইংৰাজী 16/7/2026 তাৰিখ বৃহস্পতিবাৰে সন্ধ্যা প্ৰায় 5:30 মান বজাত এজাহাৰকাৰীগণে নিবিদাৰ নীতি নিয়ম অনুসৰি বজাৰৰ কৰ সংগ্ৰহ কৰিবলৈ যোৱা সময়ত অতি দুৰ্দান্ত আৰু উদ্দণ্ড প্ৰকৃতিৰ 1, 2, 3 আৰু 4 নং পদকীয়াৰ নেতৃত্বত. This is important, lordship. Now, lordship, here 27 persons are named.
Yes.
Here, lordship, now, lordship, turn to page number 16. Who are the number 1, 2, 3, and 4? 1, Mofez Ali. 2, Dimple Hazarika. Number 3, Bhaijan. Number 4, Umar Ali. Thereafter, lordship, will find our name.
Podokyor Netritop.
Yes, lordship. These are the leaders.
Let us read the complete one. Netritop.
Yes, lordship. ওপৰত উল্লেখ কৰা অন্য পদকীয়াগণৰ লগতে প্ৰায় 30-40 জনীয়া দুৰ্বৃত্ত দলে পৰিকল্পিত ও দলবদ্ধভাৱে হাতত চোকা জুং ৰড ছুৰী কাঠ বাঁহ গোটা লাঠি লৈ আল্লাহু আকবৰ ছানাক তুলুহুম আদি ধ্বনি দি এজাহাৰকাৰীগণক আক্ৰমণ কৰাৰ লগতে বজাৰত অসমীয়াগিৰি নচলিব এজাহাৰকাৰীগণক মাৰি পেলালেও বিজেপি চৰকাৰে একো কৰিব নোৱাৰে. This type of things, lordship, amplified, completely amplified. Actually, lordship, both parties are engaged in clash, lordship, and both parties are injured. What are the injuries? I will go to your lordship.
Complete the
Yes, lordship.
অতি ভয়ঙ্কৰ ভাৱে প্ৰাণৰ নাশ কৰাৰ উদ্দেশ্যে
আক্ৰমণকৈ এজাহাৰকাৰীক গুৰুতৰভাৱে জখম কৰে. এজাহাৰকাৰীগণে কোনোমতে পদকীয়াগণৰ দলবদ্ধ আক্ৰমণৰ পৰা পলাই নিজৰ প্ৰাণ ৰক্ষা কৰে. বৰ্তমান এজাহাৰকাৰীগণ লখিমপুৰ মেডিকেল কলেজ আৰু হস্পিটেলত চিকিৎসাধীন হৈ আছে. No, lordship, this is not true. Now, lordship may kindly come to page number 19 onwards.
FIR has been lost by, what is the name of the informant?
Four, yes, Lordship. FIR is lost by four
Manoj Gogoi.
persons. They are claiming
Manoj
themselves
Gogoi
as the
is the concord
lessee of Silonibari Daily Market.
Tom Das.
Lordship. There are four persons, Manoj Gogoi, Dipankar Basu, Pranjal Das, and Uttam Das. These are the complainant. And 27 persons are named, and they are saying that they are admitted in the hospital. Now, Lordship, who are admitted in the hospital? Lordship, may kindly peruse page number 20, sorry, Lordship, 19 onwards. Page number 19, at the top right corner, Lordship will find a name, the petitioner number 1, Nekibur Ahmed. These are the medical papers related to in our petition, petitioner number 1. Page number 29, it is the petitioner number 2, Rekibul Ahmed, in the left corner. Lordship will find the date also, the petitioner number 2, his medical papers. All are admitted in Lordship, Lakhimpur Medical College and Hospital.
Teams also, I think. No?
Yes, Lordship. Now, Lordship,
Naharlagun also. Anyway, so
my humble prayer is that, Lordship, out of these 27 persons, Lordship, most of them are in bail. Some are getting bail from the police station itself, finding no connection. Some are getting bail from the Sessions Court, Lakhimpur. But, Lordship, these 3 petitioners' bail petition was rejected. So, Lordship,
who
be
are they?
protected.
They are Nekibur Ahmed.
Yes,
Rekibul
Lordship.
Ahmed.
And
Jizul
Lordship,
Haq.
as per the FIR, we are, Lordship, 3 persons, Nekibur, Rekibul, and Azizul. Azizul's name is at FIR name 16. Here, Lordship, in page number 16.
Nekibur is accused number 5. Rekibul is 5, 6, and 16.
5, 6, and 16. Lordship will find at third petitioner's name at
Azizul.
16. Lordship, we may be protected. We want to appear before the
No, because
IO,
the
Lordship.
allegation-
We
My
want to
lord, first of all, my lord,
participate.
his submission is that, my lord, there is nothing in the FIR, everything is false.
No.
Otherwise, my lord, all other persons were
I have
granted
not-
bail, only
Because, see,
3 accused persons. bail
on the
also.
face of it, we have to go by the FIR. If we do not have anything else, we have to go.
FIR itself reflects that, my lord, 30-40 জনীয়া দুৰ্বৃত্তৰ দলে পৰিকল্পিত ও দলবদ্ধভাৱে হাতত অতি চোকা যেনে
Lordship,
দা জোং ৰড
Allegations are serious.
Then thereafter, my lord,
Lordship, may I submit one
ভয়ংকৰ ভাৱে প্ৰাণনাশ কৰাৰ উদ্দেশ্যে প্ৰাণঘাতী
Lordship, may I
আক্ৰমণ
submit one
কৰি-
thing, only one thing? Just a minute.
এজাহাৰকাৰীজনে কোনোমতে পদকীয়া এজনৰ দলবদ্ধ আক্ৰমণ পলাই নিজৰ প্ৰাণ ৰক্ষা
FIR,
কৰে।
Lordship,
All
FIR
are
says
under
that
treatment before the-
FIR, Lordship says that 30-40 persons are attacking. Who is attacking whom? It is
No, because
it is
they are
not
named.
clear. But
No,
Lordship,
Case diary and medical report. at
Lordship,
least.
1 to 4 FIR
Case diary and
says
medical
that they under the leadership of 1 to 4. We are not 1 to 4, Lordship. So, Lordship, at least, Lordship, we may be protected so that we can help the
G.
investigation.
Tomo, learned counsel for the petitioner, and P. Botakur.
Selection order.
So just write shortly. Call for the case diary of North Lakhimpur PS case number 225 or 26 under so and so section, along with medical report. If any, full stop. You give short if necessary. List on
7th of September.
Oblige.
May I please your lordship?
Oh, madam.
Lordship, it's an application under section 482 of BNSS for granting anticipatory bail. Lordship, allegation against me are under section 79, 196, 299, 302, and 353 plus 2 BNS. There are 2 non-bailable sections, 299 and 353.
Mhm.
Lordship,
What is the allegation?
FIR is regarding a Facebook post. To kindly first peruse the page number 35, the Facebook post,
35, Facebook post.
page 35. This is the Facebook post, and this is shared by one Junak Kumar Nath, the main accused, number 1 accused, and originally it is taken from the second accused, which is Pritam Gogoi.
I am not FIR name accused, Lordship,
Okay.
but verbally, the informant verbally taken my name. Out of 474 person who shared this post, and police also looking for me, Lordship, and that's why I'm apprehending arrest.
It is, the
Lordship,
allegation is about defamation.
defamation. Lordship.
Defamation is not a criminal investigation.
Yes, yes, Lordship.
But there
There-
must be other sections, that is fine.
That's also
Because
there.
that is well settled.
Yes, yes.
Lordship, my humble submission is that to kindly protect me with interim.
32, my lord,
Media
302,
so to
79.
not which
In addition to the person, other sections are also there. Wrong FIR is lost by one, my lord. Member of legislative present, my lord.
regarding his daughter.
Lost.
No.
My lord, on my lord, bold portion of the FIR, my lord, what are the comments specifically made and those, my lord, were circulated in fact.
Lordship, my name has not been mentioned in any part of this FIR. Only police is looking for me. 2 times they came.
FIR, my lord, why he has approached, maybe, my lord, some materials is there during investigation, my lord.
Everyone has to learn to use social media responsibly, but that is easier said than done, as you know.
Lordship, I'm ready to cooperate with the
Wrong
police. I
FIR,
can
my lord,
hand
and
over the
what type
mobile
of allegations, my lord, made? Everything was there in bold letters, my lord, in the FIR, my lord.
Lordship, I'm an assistant professor of Purbangsar College, also a nodal officer in My Bharat program, conducted by Indian government. Lordship, kindly protect me with interim. I'm ready to cooperate. with the
Daughter, their father is a different person. She is a different person. Can have her views. No problem.
And those were, my lord.
Within the
circulated-
family, there can be difference of opinion.
Those were calculated, shared, my lord.
Now, that's why I said social media is a reality. It's a good thing, social media, but we should all learn to use it responsibly because it can be harmful also. Otherwise, anyway, what is his name, petitioner?
His name is Mr. Sheikh Abdul Hamid
Okay. Your Mr. Heard
Siraj Chaudhary.
learned counsel for the petitioner and P. Bhattakur learned counsel. Invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with Kamalpur PS case number 71 of 26 under so-and-so section. It is submitted that an FIR dated 21/8/2026 was lodged. Her father lodged the FIR by Mr. Diganto Kolita, who was stated to be the member of Legislative Assembly, Kamalpur. Who stated to be the member of Legislative Assembly, Kamalpur. It is alleged that the 2 persons named in the FIR have uploaded a defamatory post in the Facebook making certain allegations against his daughter, who is a law student in a university outside the state. Learned counsel submits that the petitioner is not named in the FIR and that he may be given some protection and that he would cooperate with the investigation. The learned additional PP objects to the prayer for interim bail. Call for the case diary of concerned police station, from the concerned police station. However, in the interim, in the event of arrest of the petitioner, he shall be allowed to go on bail of rupees 25,000 with one surety of the like amount, with the satisfaction of the arresting authority, and subject to the conditions that he shall cooperate in the investigation, appear before the IO, making himself available for examination. He shall not hamper or tamper with evidence. Full stop. He will not misuse his liberty to commit any offenses or illegal activities.
Highly advised.
List the matter on 18.
Yes.
Item 12.
Your Lordship. So for affair case 11, Lordship. Affair case 11, Lordship. One police personnel filed this affair, Lordship.
FIR is at page 11.
Page 11, Lordship.
Some drug seizure or something.
No, Lordship. Actually, some local public apprehended one vehicle, Lordship,
Hmm.
transporting illegal cattle, Lordship.
Hmm.
They informed the Gauhati police, they come so lately, Lordship. There is some altercation took place, Lordship. Only 3 numbers of person arrested. They are subsequently returned bail by the Romania court, Lordship. Where the
Order is here.
100
The,
of people.
the learned court below,
Yes,
below
Lordship.
that order is there.
17, Lordship.
17.
We are not opposed, Lordship, with some arrested, Lordship.
This is regarding some other
Yes,
issues.
Lordship. This was a regular bail, Lordship.
Who is the present petitioner?
Mr. Lordship,
Putul
we have the
Burman.
villagers, two person, Lordship. One
Putul
Putul Burman and other will Moon
Putul is named. The other one is not named. Moon Burman is not.
Burman, Lordship. They are FIR name, Lordship, but there are 100 of people also get us, Lordship. 100 of villagers, Lordship. Actually, they apprehended a vehicle, Lordship.
A.K. Ahmed,
transporting illegal cattle, Lordship.
learned counsel for the petitioner. The two petitioners herein, namely so and so, are seeking anticipatory bail in connection with Gauhati PS case number 168 of 26 under so and so section. In the FIR dated 29/7/26, lodged by SI Dhanjit Deka, Gauhati Sarli PS, it is alleged that on 28/7/26, in the night around 10:05 PM, a police team had gone to make certain seizure, whereupon group of unruly persons abused them and even assaulted the driver of the police vehicle. The allegations are serious on the
Yes,
face
my
of it,
They take my lord even police vehicle, my lord.
but this is, what is your submission? On the face of it,
Actually, on
it's
the day,
serious.
100 of local public gathered their, Lordship.
Why? Because the,
They apprehended a vehicle, Lordship, transporting illegal cattle, Lordship.
oh, okay.
They accordingly inform the police, Lordship. Police come so lately, Lordship. So there's an altercation took place. I am admitting, Lordship.
Have you
But this
stated
was-
that?
Yes,
Have you stated that?
yes, Lordship. Para number 4, Lordship. In my petition, Lordship.
Full stop.
Page number 4, para number 4, Lordship.
The drawing attention to para 4, Mr. Ahmed, learned counsel, submits that the allegations in the FIR are exaggerated, and that the real facts are that a vehicle with cattle was apprehended by the public and police was called, but police was unusually late in arriving at the spot, due to which there were some altercations, whereupon the FIR came to be lodged with exaggerated allegations. Right?
According to
This
the driver of the said vehicle, filial, Lordship. According to the driver of the said vehicle, filial, Lordship.
drawing attention to order dated 17/8/26, the learned counsel submits that by the same order, said order, the court of the learned JMFC, Rongia, was pleased to grant regular bail to
3 accused persons.
three accused persons who are named in the FIR. First, the petitioner number 1 is named in the FIR, but petitioner number 2 is not. Right? Petitioner number 2 is not named in
No.
FIR.
Present accused persons are petitioner number 4 and accused number 4 and 6 in the
Yes, Lordship.
4 and 6.
4 and 6. my lord.
Where?
It is
In
in
the
the
FIR,
FIR.
Lordship.
my lord,
Oh, it's a
page
Moon
11.
Burman, okay. The petitioners are named in FIR.
Putul Burman, 4 and my lord 6, Moon Burman. Third paragraph. my lord.
Middle portion, Lordship, third paragraph.
Third paragraph, third line.
Call for the case diary. However, in the interim, to facilitate the petitioners to cooperate with the investigation and also keeping in mind the bail granted to the arrested FIR named co-accused, comma, it is directed that in the interim, in the event of the arrest, 25,000 each. Conditions, they shall cooperate, they shall appear for examination, they shall not commit any offenses or illegal activities. East on 22.
Yes.
I love this question.
Yeah, FIR, your lordship will find page 12, lordship.
Yes, please.
The petitioner is not named in the FIR. The main allegation which I have understood from the FIR is that one person, lordship, he contacted some students saying that he will get them admitted in a B.Ed program, lordship. And accordingly, he demanded money. And one of the person is arrested, lordship, in the present case, that person who demanded money. And from his forwarding report, what it appears, lordship, he has confessed that I could not annex, lordship. I'm sorry, I'm just reading. I will hand
No
it over
problem.
to your lordship.
No.
The arrested accused himself admitted that he chose to cheat people because he was facing financial hardship. He
Anyway,
was cheating
the
people. lordship.
petitioner is not named.
Petitioner is not named, lordship, but he was asked by the police to appear before the police station
That is
without
myself.
giving notice. So he do not know, therefore he is apprehending. I am handing over that forwarding report. And one order granting him bail also, lordship. They are indicating the progress of the investigation.
Otherwise, allegations are serious. It seems that, my lord, not only that unknown person, other persons of the from the university also involved.
Forwarding report ground number 4, lordship, may I kindly see. For cheating people, he have done whether actually there was a manipulation in examination or that is not there. But it appears that he tried to cheat people, lordship, that person who was arrested. And forwarding report also says, lordship, that on perusal of the case diary, that part, lordship, may I kindly see. Second page of that order, lordship, granting bail, lordship.
Nobody is named in the FIR. No?
Nobody is named.
My lord, unknown person later on, my lord, during investigation.
Known persons.
Phone recording is there, perhaps that Madhurya, he contacted everyone, lordship, for cheating them. He will appear,
We
lordship.
can
he
see
will
the
be
FIR,
appeared.
yes. We can see the case diary.
Lordship.
Till then, maybe,
Then maybe he may be protected.
just don't know. Let him record his version. A. Ahmed, learned counsel for the petitioner. And P. Bhattakur. Invoking 482 BNSS, the petitioner, namely Kamleshwar Chotia, is seeking anticipatory bail in connection with Dibrugarh PS Swansea. An FIR dated 4/7/26 was lodged by Mridul Kumar, Deputy
Mridul.
Registrar Administration, making certain allegations about certain illegalities which has come to notice regarding admissions in B.Ed and the involvement of some unknown persons in the same full stop. One person was arrested during the investigation. The learned counsel, Mr. Ahmed, has drawn attention of this, has placed a copy of the forwarding report. He was subsequently released on bail
But release order also I have.
and subsequently released on bail
On lordship.
on 4/8/2026, passed by the learned CJM Dibrugarh. Full stuff. Call for the case diary. However, as petitioner is not implicated by name in the FIR, it may be fair to give him an opportunity to record his statement and render his cooperation to the investigation into the alleged anomalies, alleged illegalities. In such view of the matter, it is in the interim, huh? 30,000 with unsevered. By condition of will cooperate, appear for examination, shall not hamper or tempt. It's list on 16. You can take this back. You will need.
Pablo. Pablo. May I please, Lord? My Lord, this is my Lord PDR's bail application, and your lordship will find FIR at page 12.
Yes.
Page 12. Now, lordship kindly see in the my Lord, top, my Lord, the age of the victim, 28 years. And she is a my Lord, mother of 2 children.
Let me go through that. Yeah.
Now, lordship kindly see the status of the my Lord petitioner at page 15. He is a my Lord, government employee, page 15. Then my Lord, lordship kindly see
He's
the
head
my Lord-
teacher.
Yes.
He's head teacher.
Now, genesis of the case, lordship kindly see, my Lord, we have chronologically annexed the my Lord, land disputes between the my Lord, petitioner side and
Yeah.
the.
There has
public
to be, you have to show something, otherwise you will
Yes.
fall for the case that
Now, lordship
on the
kindly
face
see
of it, it is serious.
page 17, page 17, first kindly lordship.
Because,
This is-
because we know in certain situations, this,
Yes.
some people have become little vulnerable because of this election related
Yes,
names
yes,
related,
yes,
identity related documents. They can be vulnerable. So she's gone to get her name corrected in the voters ICAR, which
Yes.
which
That
may
is,
have
that-
which
that
may she may require for other purposes also.
That is,
So suppose if a person takes advantage of that, that's very wrong. Anyway, that is the allegation.
yes, that is the allegation. Now, lordship kindly see page 17, the genesis of the my Lord case. Page 17, lordship kindly see. This is, lordship will see, my Lord, date relevant, middle portion, my Lord, 19/7/2009. The, my Lord, my own sister lost complaint against the my Lord, lordship kindly see, number 1, Basiruddin, father-in-law of the informant. Number 2, Motiar Rahman, husband of the informant. Lordship has seen. Name and address of the accused.
Wait, just I have to take it down. Not this.
Yes.
Dustbin to থাকে না? Basiruddin,
Yes.
this FIR is dated. This is a complaint or
This complaint
a
lodged by my
complaint?
own sister, lordship kindly see, Roop Banu Bibi. Lordship has seen in the top.
Complaint dated.
Complaint dated, my Lord,
This date is important.
19/7/2009.
Filed on my lord 4th September 2025, page 29.
2009.
Yes,
25.
2009.
9. The genesis, my Lord, we have chronologically annexed, my Lord. Page 19, lordship will find 19/7/2009.
This is the date of the complaint.
Yes.
It was lodged by
By my own sister, my Lord, Roop Banu. Lordship kindly see in the
Roop Bhanu,
Roop Banu.
the petitioner's sister.
Yes, petitioner own sister.
Sister.
Now, against
Okay,
whom lordship
sir.
kindly see,
A1 is
A1 is my Lord, Basiruddin, father-in-law of the informant.
informant and
Yes.
A2 is husband of informant.
Yes, 2 is my Lord, husband of the informant. Then again, lordship kindly see page 21. This is the my Lord, title suit. Again, my own sister, page 21. And Basir and my Lord Mujida, they are in-laws of the informant.
This is a title suit.
Yes, title. between the same parties. My lord.
Yes.
The in-laws.
Yes, in-laws.
Okay, then.
Now page 30, lordship will find another my lord, CR case my lord pending between the parties. Page 30. My own sister and the lordship will see the accused person, in-laws and husband of the informant. Page 30, lordship will find.
Husband's name is Motiur.
Yes, motive. This case has been lost, my lord. They, my lord, recorded their land name in the my lord, land belonging to me, my daughters, showing him my lord death. So that case is pending. Now, lordship, kindly see the my lord mutation case we have filed. My sisters, lordship, kindly see page 37. Page
Okay.
37.
Mhm.
Solimuddin Sheikh,
Mhm.
the petitioner before lordship, and Rup Banu, my own sister.
Mhm.
Our lands, my lord, their name has been incorporated, showing my sister is a dead person.
Mm.
And ultimately, my lord, on the basis of the my lord, complaint that has been rectified by the my lord, circle officer, lordship will kindly see page 39. Page 39. My lord, serial number 2, my lord, the petitioner, and 6, my lord, Rup Banu, who is my own sister.
Mm.
Now, this is the my lord, land dispute between the parties. Because of that, my lord, the counter blast has been my lord, filed against the petitioners. My lord. That is the my lord, entire facts we have narrated, my lord. So, my lord, lordship, kindly see the affair. It is totally absurd. She came and entered into my home, and I have committed some physical agression.
Rape.
Can it be believable? My entire family members is there. My wife is there. My son is there. My daughter is there.
Otherwise, my lord, possibility is that my lord taking advantage of all those pending cases also, he may commit this type of
Yeah,
offense.
but as I said, per se, I mean, it's not, nothing is impossible, but the per se, yes, it is allegation serious, but in the backdrop of these disputes, so he has to be given some benefit of doubt. Because otherwise he is a teacher also, head teacher also. The person has to be mad to, in such a position to do this kind of act.
Yeah.
Suppose.
Otherwise, his submission is that, my lord, because of all these pending cases, my lord, he has lost this fall. But otherwise also, my lord, that may be, my lord, because of all these pending cases, the case may also be that, he may, accused person may took advantage of that situation. My lord.
This is my lord, absolutely my lord, planted case because of my lord, this situation.
Submission. my lord.
Mr. M.U. move to learned counsel for the petitioner and P. Bhattakur, full stop. Invoking section 482 BNSS, the petitioner, namely Solimuddin Sheikh, is seeking anticipatory bail in connection with Fakirgan's PS case number 89 of 25 under some section. Full stop. The case arose out of an FIR dated 21/7/2026 lodged by the alleged victim woman with the allegations that on 27, on the previous day in the morning, she had gone to the house of the petitioner for correction of her name in the EPIC card, as because the petitioner was a BLO, and that there he committed sexual assault upon her. Next paragraph. Mr. Mondal, learned counsel, submits that the petitioner whose discharging duties of BLO is head teacher of Janamangal LP School, the district of Dhubri. His identity card has been annexed as annexer 2. The learned, taking the court through the relevant annex documents, the learned counsel for the petitioner submits that a complaint. This was registered as which complaint? CR case number? The first one. 2009.
First
Is it
one, my lord,
still
number is
pending?
not available, my lord. We have annexed the, my lord, vernacular portion, page 19, lordship will find.
The sister of the petitioner had lodged a complaint
Per number.
dated 19/7/2008 against 8 accused persons, of which A1 is the father-in-law of the informant and A2 is the husband of the informant. Full stop. It is further submitted that the title suit number 178 of 2025 has been filed by Rup Bhanu Bibi, the sister of the petitioner, against
In loss of the informant.
the in-laws of the informant. It appears that another complaint case being CR number 426 of 25 filed by the said Rup Bhanu Khatun, said Rup Bhanu is pending against the in-laws and husband of the informant. The learned counsel also draws attention of the courts to certain revenue and mutation documents annexed with the bail petition. In this backdrop, the learned counsel submits that the allegations are false and concocted and lodged in the backdrop of this, in the background of the ongoing disputes between the parties. It is submitted that the petitioner completely denies the allegations. The learned additional PP submits that the allegations on the face of it are serious. Call for the case diary. Nevertheless, in view of projected circumstances, it would be fair to give an opportunity to the petitioner to record his statement. Therefore, in the interim, 30,000 one severity, tinta conditions rebo, cooperate, appear, hamper or semper, shall not hamper or temper, and fourth, he shall not, the petitioner shall not commit any intimidation or harm upon the informant or our family members. So, violation of the bail conditions would entail cancellation of the bail. This is the matter on
23/9, 23/9,
23/9.
23/9.
Deep lawless.
It's 2%, a short break long, 5 minutes. Or long, but I was too much. Yes,
May I please, sir? Okay, appear at page 10A, Lordship, last page of my petition. So basic allegations of forgery and cheating. I am reading the affair. Last page.
10.
An information was received from reliable source that certain POS, point of sale, of Hauragat region selling SIM cards of Reliance Jio is suspected to be involved in fraudulent selling of SIM cards which are used in cyber crime activities, and accordingly upon initial inquiry by Sri Sajidur Islam APS Deputy Superintendent of Police in coordination with the TSP, it is revealed that one such POS so and so belonging to one named Manoj Chanda, son of so and so, Hauragat has sold more than 100 SIM cards. I am not Manoj Chanda. In recent past, to customer having addresses belonging to Lahorigat and Moirabari of Morigaon district and Thing of Nagaon district, with the help of one Injamul Haq, son of so and so, address so and so. I am not Injamul Haq, who works with the Reliance Jio. Now my starts, I am Ayub Ali, and Ayub Ali, so and so, who used duplicate biometric of Monos to access the POS portal to activate the new SIM cards. And coincidentally, these SIM cards are already reported to be involved in cybercrime financial fraud, which raises great extent of suspicion of their involvement in fraudulent activities. Lordship,
Manoj Chanda is the authorized distributor of Reliance Jio, and point of sale belong to him, Lordship. I am one of the employee. And as per direction, whatever I have done, Lordship, as per direction of Manoj Chanda, and in presence of Manoj Chanda, now the allegation brought, I have duplicated the biometric. Biometric cannot be duplicated, Lordship. And
Actually-
Lordship, the prime request, Lordship, Manoj Chanda and Injamamul Haq already been arrested, Lordship. I am
Actually, in a way, one of the main allegations is also against
Against
Ayub Ali.
Ayub Ali, my
Because biometric, you're right.
Yes,
Actually,
yes.
biometrics are not meant to be replicated. That is why they are biometrics. Your iris and your fingerprint is your unique thing.
These are serious.
Anything is
serious cyber
possible with
offenses.
misuse of technology nowadays.
These are serious cyber offenses, my lord. So
Let us see the diary,
the city
Mr. Sarkar. Because it won't be prudent to grant interim in this case. Let us see the diary. You hold on for a few days. Mr. Sarkar, learned counsel for the petitioner. He call for the, I will not say anything, call for the case diary of Haraghat PS case number so and so. The case arose out of an FIR dated 9/8/2026, lodged by Inspector S. Shyam of Haraghat PS. List on, you work out.
Lordship on 7th, along with BA number 2455/2026. BA number 2455/2026 on 7th of 9 September.
Wait, no. Just 5 minutes.
Of being arrested, Lordship, by the Howley PS police station, Lordship. Here, Lordship, petitioner one is the husband and who is his business partner, and the dispute due to matrimonial discord. And due to matrimonial discord, long back they were used to stay separately, Lordship. Now this police, this affair has been lost. In fact, lost in the affair. He has, but police without issuing any 35(3) notice or insisting his presence, and he has apprehension, the reasonable apprehension that he will be arrested in this case.
Okay,
He will
no
be
problem.
arrested, Lordship. So may I pray, Lordship, no.
We'll call for, because there's no GD number, report, we'll call a report.
So meanwhile, Lordship, you'll be appearing before the police station.
Because we'll need I can give, the court can give a direction for no coercive action.
Yes, Lordship.
But for
Lordship.
release on bail, we need a number actually.
Lordship, no
So let the
coercive.
report come.
Lordship, no coercive action.
He's home, learned counsel for the petitioner. The petitioner is seeking anticipatory bail in connection with a purported complaint against him lodged by his wife in Howley PS. Full stop. However, he does not have details of the same. Lodged by the wife of petitioner number 1. The petitioner states in para 3 that his wife has purportedly filed a complaint alleging cruelty, etc., and illicit relationship between petitioner number 1 and 2. Full stop. Next paragraph. Call for a report from the concerned police station regarding filing of any such complaint and registration of any case, and if so, case particulars. Full stop. Next paragraph. Meanwhile, till the returnable debt, and with regard to any such complaint, the petitioners shall not be subjected to any coercive action. List on. Take it after a week, because next week is very short. 8.
8, 9.
Obliged, Lordship. Ditya.
May it please your Lordship. Lordship, this is a pre-arrest bail application, Lordship, absolutely on civil dispute, Lordship. May I take the FIR that is on page 22, Lordship? 4 persons are named in the FIR, Lordship, and accused number 4 already been arrested, Lordship. I am for accused number 1, 2, and 3.
Initially, Lordship, the informant lodged in the affair stating that Lordship, he has not sold that land to this two petitioner. But in fact, Lordship, I have annexed the document. It was sold to the Lordship petitioner number 2 as well as petitioner number 1, Lordship, with a registered document. Thereafter, Lordship, petitioner 2, the name has been muted. But in case of petition number 1, Lordship, that was title sheet was filed, Lordship, that I have annexed also, Lordship. FIR, Lordship, will find page 22, Lordship.
Twenty-two,
Yes, Lordship, 22.
the complaint, huh?
Yes, Lordship.
No, SP, it's fine, it's preferred for SP.
Absolutely, civil dispute, Lordship. Title shoot is pending, Lordship. I have annexed the title shoot also, Lordship. Register sale deed, Lordship, will get on page 30, Lordship.
Allegations are little, you know.
Uh,
What
case-
case is this title suit is also fraudulently instituted according to the informant.
Page 30, Lordship, that is a register sale deed, Lordship.
Page 30,
30, Lordship.
which the complainant says to be fraudulent.
Yes,
He-
Lordship,
he
that
says it is
initial, no,
fraudulent.
Lordship, that he said it's fraudulently taken, but it's a register sale deed, Lordship. His photographs is there, Lordship.
Achha.
That, Lordship, page 34, Lordship. We'll find that present petition, informant.
Nowadays, there are a lot of checks and balances also in this document.
Then, Lordship, what happened? Biometrics is also there, Lordship. Thereafter, Lordship, what happened? The name of the petitioner number 2, Lordship, already muted. That I have annexed, Lordship. Page 44, Lordship.
Injunction.
Page 44, Lordship. That is the Jamabandi copy, Lordship.
Civil suit is pending.
Yes, Lordship.
Yes,
Civil
181.
suit, Lordship, that is, Lordship, will find on page 47 onward, Lordship.
Earlier,
Yes.
my lord, in many cases, what happened, my lord, initially they manipulated all these documents in the office of the registry, and thereafter, my lord, those documents used in the civil cases.
It was, Lordship,
Before the civil court,
National
and
Law
thereafter
Adalat.
obtained favorable orders from the civil court. Regarding that, earlier many other cases, but in this case, my lord, because he submitted that he has also appeared before the registry and photographs were taken at the time of registration of the, my lord, that sale deed, my lord.
Nowadays, as I said,
Now, Lordship, page 48, Lordship. It's an order of the National Law Adalat. They have challenged that order,
My
Lordship.
lord, in many cases, those documents itself.
these things were done earlier. This is a Lok Adalat order.
Yes, Lok
No,
Adalat.
no, not 48. 48 is a civil court order.
They have challenged the Lok Adalat order, Lordship, before the civil judgment. Absolutely, Lordship. Civil dispute, Lordship. Kindly protect this petitioner, Lordship.
He said that only civil dispute, if my lord, they are involved in.
Land had already been muted in the name of the second petitioner, and in the regarding the first petitioner, he said, Lordship, it was their Lordship. That's why, Lordship, we have challenged that order, Lordship.
If my lord.
In Lok Adalat, it was settled, Lordship.
The title suit has been instituted by
By the informant, Lordship.
informant. Okay, informant.
Yes. Abdul Qadir, Lordship.
Seeking setting aside of the sale deed.
Sale deed, Lordship.
He claims that it's fraudulently taken.
But it is against Abdul Hussain. Regarding Abdul Hussain, Lordship, that is against the petitioner number 1. Regarding petitioner number 2, he has not said anything, Lordship.
Investigation will reveal whether any.
Civil dispute, Lordship.
No. Everything cannot. Civil dispute may be a side. Civil dispute does not mean that there is
Already, Lordship, that the mutation in the name of the petitioner, Lordship, two petitioner, their name is their lordship. Mutation order lordship will find on page that is
Disorderly
Jama
learned
Bandi
counsel
copy.
for the petitioners. The four petitioners herein, three petitioners herein, namely so and so so and so, are seeking anticipatory bail in connection with Tezpur PS case number 462 of 2026 under so and so section. Full stop. The case was registered based on an FIR dated 3/8/2026 lodged by one Abdul Qadir. The gist of the allegations is that the accused persons in collusion and conspiracy committed forgery, impersonation, cheating, and manipulation of documents and trying to illegally obtain ownership of the complainant's land. Full stop. The petition, it appears that the informant has also instituted a title suit being TS number 181 of 23 before the Court of the Learned Civil Judge Junior Division, Tezpur. Full stop. Mr. Chaudhary, Learned Counsel, has taken the court through some of the documents pertaining to the civil transaction, purported civil transaction between the parties, including the, what is that document which you showed? Where is, including the sale deed
And Jama Bandi copy.
bearing biometrics of his fingerprints. Full stop. A mutation document has also been annexed with the bail petition and brought to the notice of the court. Full stop. It appears that the petitioner, the informant, has also challenged the order dated 9/9/2023 passed in the title suit in Lok Adalat. All the things have been preferred by him only, actually. It falls in place, actually. He claims manipulation. Then he claims he has filed title suit to set aside the sale deed. He files a petition to set aside the Lok Adalat. Lok Adalat order, to my mind,
Probably,
as
my
far as
lord,
I know, it can only be challenged by writ petition.
if my lord subsequently, my lord, he has changed him, may also, that may also come out during the investigation, whether he has, my lord, he himself has, my lord, involved in, my lord, first.
Call for the case diary. However, in view of the projected materials and circumstances, the possibility of the case arising out of civil dispute cannot be ruled out altogether at this stage. Therefore, the petitioners can be given an opportunity to record their statements. In such view of the matter, call for the case diary. Again, 25,000 each. Number one, corporate appear for the IO and shall not harass or intimidate or the informant or his family members in any manner. Shall not hamper or tamper with evidence. Violation will entail cancellation of the bail. You get it in this week, 7 to 11, that week you get.
Yes.
9?
Can it be lordship after 12 lordship?
Let it be in this week only. Let them record their statements.
Yes. 11/9.
11.
Highly okay.
Yes.
Sir, in this case, my lord, your lordship may kindly peruse earlier order of this honorable court dated 14/8/26. My lord, I was asked to personally appear before this honorable court because earlier, my lord, one vehicle was seized in respect of an NDPS case, my lord. And regarding that, one petition was filed for asking for Zimma of that criminal division petition was filed before the honorable court.
Here.
And my lord, at that point of time, as because in spite of my lord repeated calls, that report was not sent by the IO, and my lord, later on this personal appearance of the IO was directed, and today IO is present, my lord.
Okay.
And in fact, my lord, actually, my lord, CD was earlier, since earlier, that is, CD is before this office of the, my lord, has handed over the case diary, but report was not there. Oh, he has submitted a report. No?
This report is
And he personally also, my lord, present.
basically, my lord, my case covers
under the fourth scenario of Biswajit De case.
Mhm.
So basically, I have made an agreement to sell my vehicle with another person, that is Saddam Hussein, just before the seizing of that vehicle. My
He
lord,
was implicated.
yes,
Saddam Hussein.
yes.
And my lord, till now investigation is going on. Ultimately, my lord, what are the materials?
Actually, in a revision, we have to see the correctness or otherwise, as you know,
Yes,
of that order.
But-
so up to date JIMA report, will it help?
yes, my lord, it can be. Because
So we cannot really, because
Modul,
see,
the Modul Limaye case, my lord, the state of
today-
Maharashtra,
today the order, that day the order might have been correct. Suppose
that day, yes,
that day.
maybe.
But today, in view of intervening circumstances, suppose investigation stands completed.
But my lord, there was no reasoning whenever it was rejected.
That we'll see. That will see. Anyway, you have come from Korimganj. The CD was here only.
Yes, my CD is. Now, my lord, he submitted one report.
Keep it to record. Mr. BM Deka, Land Counsel for the petitioner. Additional people, learned. Learned, Mr. Bothakur learned. First you write this, madam. Para 27 or so. 27, second paragraph, you can take it. Was filed, full stop. It appears that during the pendency of this revision petition, a report was called from the investigating officer. In this context, learned additional PP has drawn attention of this court to order dated previous order dated 14/8/2026 passed by a coordinate bench of this court. Full stop. From perusal of the order, I find that due to repeated failure to file a status report, the IO of the case was directed to be personally present. Full stop. Accordingly, you are Mr. Kaushik Burman, SIP Kaushik Burman, the investigating officer of the case is present. Investigating officer of the case who is posted in Karimganj police station.
Bazarisara
Police station. Present. For the assistance of the court and in terms of the direction dated 14/8/2026. The learned additional PP has submitted that the case diary of the matter.
Yes,
Case diary of the matter was in the registry of this court.
No, my lord, here with us.
In the office of the public prosecutor, and that is one of the reasons why there was delay in submission of the report. Today, the report has also been submitted by the investigating officer. The report shall be kept in the record. The personal appearance of the IO, Mr. K. Burman, is recorded, and his further personal appearance is dispensed. Okay.
I may be allowed to send back the CD because NDPS case, my lord.
You can go back and
Otherwise,
continue with the
from his
investigation.
report also
The
he has
investigation is stated to be continuing in the case. The learned allowing the prayer in this regard, the prosecution is permitted to return back the case diary. So we'll take it up and dispose it of.
My lord, may
Fix
take it
it
up today itself.
Today, some time constraint is there. We'll take it up on
Next
another
Tuesday,
day.
my lord.
On a next day, we'll take up. Take it on next Tuesday or Monday.
My lord, because why I'm harping on a short date, because that was seized on 14 to 2024, more than 2 years, 2.5 years, my lord. That has been lying.
Vehicle is in the police station.
Now,
in the
my lord,
police station.
yes, his report, my lord, he submitted that, my lord. Jimma to the petition subject to the condition, my lord, otherwise there is no difficulty in handling. My lord.
My lord may decide it then.
Oh. I can fix any, so next. So this.
The vehicle is stated to be in the police station.
Police station.
Police station. Till the disposal of this revision, the steps shall be taken that the vehicle is kept in proper condition and not allowed to deteriorate. You have experience in these things.
Yes.
Keep it properly.
Yes.
Vehicles are always difficult to keep in police station. We'll fix a date and fix it, finish.
My lord. Next Tuesday, my lord.
Next Tuesday, or actually, I would have been happier if I could give it in 7th that week, because next week is very short. But if you are very keen, we'll fix on 3rd.
Why am I harping for a short date? Because I have already explained, my lord.
Oh, you are very keen, so I have understood. Okay.
Much obliged, my lord.
Respect. 2 or 2nd or 3rd?
Second. My
3rd.
lord, let me check, my lord. Let me check. My lord, third.
Okay.
Third.
3/9.
Third. Much obliged, my lord.
You, Mr. Botak, will not need the CD for disposal of this?
PD, otherwise his report is available in the case.
Okay.
Otherwise, my lord, NDPS case, my lord, they will also have to, my lord, with the investigation.
That might require, my lord, till 3rd, that may be kept here, my lord. Because again,
Then we modify that. You want to send it with him? That
Oh,
means.
yes, my lord.
oh, that is my lord.
Impugn order is that, is the impugn order?
My lord,
14.
impugn order is at 21/01/2026.
Okay, I think whatever materials we have along with his report
Yes.
and that judgment, we
Yes.
can dispose it off.
Yes, my lord.
So CD, let him, since
Yes.
he has come, let him. You can take back the case.
That observation may be there, my lord.
No observation.
Okay, my lord.
The learned counsel, Mr. Deka, submits that his case for interim custody of the vehicle is covered by the principles laid down by the Honorable Apex Court in the case of Bisalde,
Biswajit Day, my lord.
Biswajit Day versus State of Assam. Citation, I don't remember, 2025, some in SC. You can give neutral citation.
2025 3 SCC 241. Much obliged, my lord.
Idu kiman আছে?
Your lordship,
Yes.
my case is at serial number 18, admission hearing,
It's also part heard.
and I have a case in another court number 4. If the bail hearings are completed and if I come later on,
Okay.
I may miss that also.
No problem.
So if it is,
You do that matter and come. We'll take it up after 2.
okay.
Item number 32, my lord. As per last order dated 26/3/26, this bail application shall be considered after examination of at least 3 prosecution witness.
Yes, sir.
As per last order, lord.
So last order dated 26/3/2026.
Just a minute. No? We are taking up bail hearings now. No? Again. Just a minute. Okay, I'm coming to this. In 32 day. Right. Yes, please repeat.
Last order, lordship, dated 26/3/26. As per the order,
26/3.
this bail application shall be considered after examination of at least 3 prosecution witnesses. That will help to
At least 3 prosecution.
yes, lordship.
What happened, lordship, after this order, lordship, about 5 months less, lordship, but till date, lordship, no witnesses has been recorded, lordship.
Last can copy as record, lordship, last date was 4/4/26 for CC, consideration of charge.
Sorry, lordship, 11 months, 9 days.
So, and commercial quantity section is also applicable.
Yes.
That also has to be seen.
Yes, Lord.
So 6,800 Yaba tablets.
Because if you want any variation of this condition, then it has to be, it would be better if it is before the same court.
But
And
Should we take it up? Or
tell it the updated scan copy may be called for, because last scan copy report was 4/4/26 dated for consideration of charge.
lordship, what happened, lordship, I have mentioned, lordship, this matter, because, lordship, after the order, lordship, 26/3, lordship, till date, lordship, no, lordship, witnesses has been recorded, lordship.
Charge is paid.
Last time, lordship.
so even if witnesses are examined, suppose
Yes, lordship.
he has
Witnesses,
been in custody for 11 months.
11 months.
And there have been people who have been in custody for even longer. And 37, locks you.
Yes.
I mean, 37 law has its own logic. Commercial quantity cases are supposed to be their commercial quantity is actually pertaining, is supposed to be for drug traffickers. not consumption. So drug traffickers, definitely, the law is very strict. So that means almost no bail. Understanding is that 37 materials are there, no bail. But trial should not remain stalled.
Yes.
No bail.
Also, at this stage, Lordship, remaining date, what happened to it? And next date is the next date.
And the regularly, Lordship, as per my instruction, regularly, Lordship, the witnesses were appeared, but their statements were not recorded as to why I think.
It is from
Tribhumi, present Tribhumi.
Special Just Tribhumi. Mr. Majumdar, Learned Counsel. First you write this. Mr. Goswami, Learned Additional PP, draws attention to order dated 26/3/2026, in which a coordinate bench had observed that bail petition is to be considered after examination of at least 3 PWs. In this context, Mr. Majumdar, Learned Counsel for the petitioner, submits that though witnesses have appeared in the meantime before the learned trial court, but prosecution evidence has not progressed. The scan record is available, but the learned additional PP submits that it is not updated. Right? And perhaps an updated case diary, case record may be called for. I also find that the prosecution is also a prosecution of the accused person is also under 22C/29 of the NDPS Act, and therefore the applicability of section 37 of the NDPS Act has to be seen during adjudication of the bail petition. Issue of fresh requisition for updated scan TCR comprising the relevant documents such as case diary, charge sheet, depositions, if any, depositions and any other relevant documents. Stop. List on. The petitioner is stated to be in custody since, kindly tell me.
Lordship, 19/9/2025.
19/9/2025. Like exclusive special courts we have now in Kamrup. Actually, these exclusive courts are meant for trial of commercial quantity where people are not getting bail. Mainly, I feel that is the objective. 33 is wrongly listed.
Lordship.
Mr. Abha,
Lordship, I'm appearing on behalf of Dr. P. Agarwal for respondent to amicus curiae. Lordship, we have not received the petition.
Yes, sir. Yes, we have served, Your Honor. My advocate has served.
We have not received yet.
Kindly check, cross check,
Yes,
work
yes.
it out.
My advocate has served. This will.
Learned Counsel, your good name, please.
Zedar Majumdar.
Zedar Majumdar, appearing on behalf of Dr. P. Agarwal, Learned amicus curiae for respondent number 2. Praise that they may be given a copy of the furnished with the copies. Full stop. Needful may be done. Scan record is available. So you exchange your copies, then we'll take it up. If you can exchange it today, we can take it up today also. It's up to you.
It will be.
It's up to you. Up to you. Work it out. Otherwise, otherwise when? Which day? On 2nd? On 31st or 2nd?
31st, Your Honor, I will be out of decision from 1st September, Your Lordship.
31st. 31.
31st. Monday.
You oblige.
My please, Lordship. Solicited case, Lordship. I am behind over for 118 days, Lordship. Allegation is under section POCSO Act.
Ms. Sharma, you're appearing as amicus? You're appearing as amicus?
I'm on lengthen detention, Lordship. 118 days, Lordship. Proceed submitted. A local person, Lordship, I will participate in a trial proceeding, Lordship, to defend myself.
Just a minute, let me see the. Victim girl is 12 years.
Yes, Lordship. Date
LS.
of birth is 23/14. And date of occurrence is 25/26, Lordship. Almost 12 years.
Hmm?
Almost 12 years.
You can submit. Well, here, he's already submitted.
Yes, Lordship. Yes.
No evidence has started, and the accused is stated to be a friend of her father,
Yes.
friend of her father, I think.
And I have flag marked the 183 statement of the.
Yes, his friend of her father. Very unfortunate it's true. But anyway, these things are happening. So, what is your submission? Should bail be granted now or should not be granted?
Lordship, as far as charge is not framed yet, Lordship. Let the victim be let the charge be framed and the victim will be examined, Lordship. The allegations are serious and a 180 statement she has implicated.
Lordship, I'm not on the maid, Lordship, I am on,
Yes, I understand.
180 days, Lordship, 18 days, a whole third.
Where is the statement? Implicated. But serious allegations.
Lordship, though it is registered under section 4 of the POCSO Act, Lordship, there is no ingredients under section 4, Lordship. It may be a case of under section 8, Lordship. Then its punishment is shall not be less than 3 years, Lordship. No ingredients under section 4.
No, it may be aggravated that if it is not, if it is only sexual assault, it may be aggravated sexual assault because he's below, say, 12 years, isn't it? To see the provision again. Anyway, so let us wait for some time because not be prudent. Simple. Land counsel to the petitioner. P.P. Goswami and D. Sharma, amicus curiae. Oh, sorry, I forgot to ask. You make your submissions. Do you think bail should be? You're opposing the bail?
Yes, Lordship, because the ground in the FIR forwarding report also that there is a possibility of hampering or tampering of the evidence. Not yet the victim was examined and he is a known person, so
That
the
is the
possibility is very much there, Lordship. Because the allegation is that he take her and so there is always possibility that may offense the girl also, Lordship. at least her evidence.
The counsel for the petitioner fairly submits that he's not much on the merits of the matter, but rather contending that the petitioner has been in custody for more than 100 days, and since his arrest on 3/5
Yeah, yes, sir.
2026, and in the meantime, investigation is also completed. The case poised for commencement of trial. The scanned TCR is available. The allegation is in the Azahar is about commission of sexual assault upon the 12-year-old daughter of the informant while he and his wife were not there. The accused is alleged to be a friend of the informant. The prosecution opposing the bail has drawn attention of the court to the statement of the alleged victim girl recorded during investigation before the learned magistrate. I peruse the said statement in which she has implicated the petitioner and described in detail about the incident. Stop. Ms. Sharma, the learned amicus supporting the opposition of the prosecution to grant of bail further submits that there are possibility of intimidation or of the victim girl, minor girl who's aged only 12 years, and that the accused also happens to be a person of the known circle, being a friend / acquaintance of her father. I've considered the materials and the submissions. Full stop. At this stage, the bail petition stands rejected.
Lordship, may I pay for under that lordship? Earlier order was lordships are updated this year, whether the charges frame or not lordship. Till framing of the charges, one date may be given lordship, because it's not a case of under section 4 lordship. Earlier order was, it was reflected that updated TCR was called for. It is not updated lordship, because charge was not framed. Next date was 7/9 lordship. One date may be given lordship, one opportunity.
So we've already taken
Till the
a
framing
view.
of charges.
Taken a view, isn't it? It is not updated.
Not updated.
Charge is not framed yet.
Charge is not framed.
Not report is given.
Thereafter, it was called for updated copy. It is not updated.
If that report is received, that charge is not framed. First phase of the
On earlier application, whether charge was framed or not, on
date was given.
charge was framed.
Order copy of the date was given, but charge is not framed.
Which order? Last
order.
8.
Can TCR.
Last page of the TCR.
12/8 lordship. Last order was 12/8.
Present status report.
Not updated lordship. It is next date was on 7/9 as per my knowledge was in trial court.
It was fixed on 24/8.
Yes.
When is the next date? For production and copy, it is not, it charge not it framed.
Not framed.
It will not serve any purpose by giving a date. You can file again. And
Date will be given till the framing of charges lordship. Earlier occasion was I have submitted, the honorable court was again.
let the victim be examined. No?
Yes, lordship.
Let the victim be
Yes.
examined. Very serious allegation.
I'm ready to wait lordship.
No.
One date will be given.
No. It's already taken a view. Take it to the logical conclusion. It's rejected. However, the learned trial court, however, it is hoped that the learned trial court shall endeavor to complete the trial expeditiously. Full stop. You file it, no problem. This will be in the registry only. We'll get it back.
Publish this.
So NT place है basic.
Honorable President, TCR also not received, Lordship.
Yes. Hmm?
Trial court record also not received, and no,
Also not received.
not received.
None appears today
None appears also.
on behalf of the petitioner. Stop. What about service?
Service thought we have to take instruction regarding service of notice. I have to
Uh,
go to the office note.
Service report is awaited upon respondent number 2. The prosecution shall take instructions. Issue reminder for the scan TCR of Lahwal page 126 of 25 from learned additional session judge Dibrugarh. Scan TCR shall comprise the relevant documents such as case diary, charge sheet, etc. List on. Give it on, since counsel is not there, give it little earlier. 14. 2 days only.
37.
Well, service report is still awaited, Lordship.
Yeah, please, your lordship. Lord, in this case, the petitioner was arrested on 2nd of May 2026, my lord. 118 days, my lord, in jail. My lord, something has happened, my lord, out of love and affection, my lord. The materials, my lord, and evidence goes to show, my lord, that there was a love affair in between the victim girl as well as, my lord, the accused person, that is the petitioner before your lordship. My lord, we have annexed the 164 statement of the victim, my lord, page 32. Your lordship, my lord, pleases to see. My lord will find that she admitted categorically that they had in relationship. Now, my lord, because of unwillingness of the parents with regard to the relationship of the teenager, my lord, the present case is, my lord, filed against the accused person. Now, my lord, your lordship will find, my lord, your lordship, kindly see, I have obtained the copies of the order passed by the learned trial court, my lord.
Just a minute, Mr. Sen. So, what are you submitting, Mr. Goswami, regarding service?
Yeah, Mr. Yeah, I have not received any instruction regarding service of notice. At last order, I have some instructions are there.
Record is available.
Record is available.
Up to date available.
So short date may be given, Lordship.
Lordship, kindly similar to the last order, my lord. My learned friend has submitted.
Amicus may be appointed.
On the last occasion, my learned friend has submitted, my lord, that they were out of station, my lord. That's why, my lord, the case is posted today for, my lord, service report with regard to the respondent number 2. Now, my lord, your lordship, kindly see on 22/6/2026, charges were framed. My lord, issuing summon to the PWs. PWs is the, my lord, victim girl as well as the informant mother. Now, my lord, the other orders your lordship will find, my lord, 6/7/2026 has your lordship got it, my lord. PWs are absent. Then, my lord, 27/2026 PWs are absent. Then 3/8/2026 PWs are absent, my lord. Then 17/8/2026, my lord, PWs are absent.
This, you kindly take the instructions. You take it up on 3rd. Second or 3rd. You take the instruction. 3rd will be better. Let him take let the process be complete.
Correct, my lord. But your lordship kindly said they are evading notice, my lord. That is my respectful submission, my lord. The lower court records, my lord, for other orders goes to show, my lord, they are not coming despite service of notice for reducing their evidence.
Anyway, you take the
Now, my lord,
instruction.
shall I suffer for that, my lord?
We'll appoint an amicus
Lord,
after taking instruction. Otherwise,
My lord, I rely upon a judgment of the apex court, my lord. Your lordship aware my judgment to there.
because we have to
Union of
follow.
India, my lord, versus Nazir.
We have to follow Deepak Nayak also, isn't it?
That's correct, my lord. I bow down your lordship's observation, my lord.
I understand. You're right also. Let me see that also. Judgment. Mr. Sen, learned counsel for the petition. AP Gosan. Scanned TCR is available. Learned Counsel, Mr. Sen submits that by order dated 22/6/2026, charges have been framed against the accused petitioner under section 76, 77, 308 within bracket 2 BNS read with section 4 within bracket 2/12 of the POCSO Act. It is submitted that several dates thereafter, the prosecution witnesses have not appeared before the learned trial court. Service report upon respond number 2 is awaited. The prosecution shall expeditiously take instructions regarding the same, so that the bail petition can be proceeded with. When should I fix it? Third? I'll keep this here.
Najib says, my lord, Union of India, Najib says, my lord, if there is no possibility for, my lord, earlier disposal of the trial, my lord.
Yes.
Then, my lord, the
No,
accused
no,
is then debarred,
we cannot assume immediately.
my lord, yes.
We'll let the thing appear, then we'll see. Otherwise,
Thought that may kindly be
we'll see
given.
the allegations. Can we keep this here?
Well, she may keep it. Lordship will fix it on 3rd of September.
Is it okay for you? Third?
If my learned friend able to, my lord, complete the.
Because we have only 3 days. Let it
Yes.
be on second or third. Second or third. Let him give you.
Third minute, all right. Obliged.
My lord, in this case, item number 38, my lord, today, my lord, I tried to get the instruction regarding service of notice, report regarding service of notice, my lord. Today itself, well, I will get the report.
Not yet got.
Not yet. my lord.
After some time, we'll take it. POCSO matter.
Yes. My lord, and for a moment, lordship, and kindly be appreciate, lordship, FIR page 11, lordship. And the lordship, otherwise I will have to get the report, my lord.
Yes, man. He wants to show something. Yes.
And lordship, there is the ring ceremony is completed between the victim and the petitioner, lordship. And subsequently, lordship, and to some extent, lordship, there is dispute between the victim and the present petitioner. And on that basis, lordship, FIR has been lodged, lordship.
Yes,
May I read the
Yeah,
FIR?
I'll go through it.
Lord.
I'll go through it myself.
Lordship. Lordship, no case. And
Anyway,
lordship, the page number 20, lordship, and this 48, notice 48, lordship.
Mhm.
It is not served, lordship. Otherwise, it is admitted, lordship, and on that day, lordship, and the petitioner was stayed at the house of the
yeah,
informed lordship.
he's no. It seems he's known to the person family.
Not very familiar, lordship. And their ring ceremony is completed, lordship.
Not let the matter be taken up after some time. If
Okay,
I
yeah,
get the
you
report, your
try.
lordship,
Let him
your
try.
lordship may
Let him
apply
try.
for
Otherwise-
amicus, then matter may be
Ah,
listed
then-
again on.
Obliged, deeply obliged.
Oh, man, ঠান্ডাটা কমাই দিয়ক। ঠান্ডা লাগি আছে। one minute.
Can be taken up after some time, my lord. Learned APP.
Okay, after some time.
Item 40.
Yes, please.
40 and 41, my lord.
40 and 41, your lordship. I'm praying, your lordship, can it be the next week, your lordship?
Did he receive, my lord?
It can be as you wish. It's a bail application.
Did he receive, my lord? In
Okay.
DPS commercial quantity.
He wants it next week, so no problem.
Yes.
No. Both the cases. We can fast common order, perhaps. No. It is submitted on behalf of the petitioner that the matter may be taken up next week if possible. Full stop. The case diary is received. However, the same may be written. List on which day would you prefer? Second or third? Third. Okay. Same order. Third. All right.
42, my lord, case diary not received.
Diary is not received.
Is there enough?
Get the diary.
Short date may be given, Lord.
The case diary is stated to be not received. Issue reminder. List on
8th of September.
8/9.
43 also, my lord, CD not received.
My lord, the CD not been called for, my lord. In this case,
This
this
year
year was called for, my lord.
This year not
My
received.
lord, in this case, what happened, my lord? The NBW was issued against the petitioner on 29/3/2022, my lord.
Okay.
Due to the non-appearance of the present petitioner, my lord. Subsequently, that, my lord, he was arrested on 13/5/2026, my lord. Today is around, my lord, 107 days, my lord. I am behind the bar, my lord. Then also, my lord, the still, my lord, case not been committed, my lord. As
Case
my lord-
diary or
TCR
scan record?
Sir, my lord.
TCR.
TCR may not be required, my lord. Lordship may once may peruse, my lord, the documents annexed, my lord. My lord, the case related to back to the 2012, my lord. In the subject matter of case, my lord, there is about initially, my lord, 29 of FIR was lost in the Sorbuk PS, my lord, and one FIR lost in the, my lord, Borpata Road PS, my lord. All 29 FIR is amalgamated, my lord. In this case, my lord, I am appearing, my lord. Both these cases, my lord, simultaneously running, my lord. Both these cases are sheeted, my lord. Both Borpata Road PS case and, my lord, Sorbuk Road PS case, my lord. Both cases are running simultaneously, my lord, before the additional CGM, my lord. Then, my lord, it was subsequently transferred to the SDGM, sorry, my lord, JMFC first class, my lord. In, my lord, second case, my lord, which is, my lord, GR number, my lord, 2524, my lord, I am regularly appearing, my lord. My counsel was represented in this case. I am also regularly appearing, my lord. But, my lord, due to, my lord, some communication gap, my lord, in GR case number 2778, my lord, 2012, I could not be appear, my lord. If my intention is, my lord, bad, my lord, I ought to have, my lord, avoid both the trial, my lord. But in the, my lord, second case, my lord, 2524/2012, my lord, I am regularly appearing before the same court, my lord.
The case in which you are seeking bail, that is.
I am seeking bail in the 2778, my lord.
That is here that is Sorbok 198.
Yes, my lord. That is the subsequently GR as 2778, my lord.
2078. No.
I am behind our 110 days, my lord. 107 days, my lord. Today, my lord.
The other cases too. The GR
2524.
2078 is the one you are seeking. And 2524.
24, my lord. Oblique
2524.
Yes, my lord. Oblique 12. 2778/12. Both are
In which okay.
My lord, even my lord. My lord, still, my lord, case not been committed, my lord. Due to my, there are several accused that, my lord, all are not.
The additional PP or APP had opposed the bail before the learned trial court, saying that because of his non-appearance, the trial got delayed. Therefore, it should not be. Anyway, so on his undertaking, give him a chance.
Any condition, my lord.
But
Yeah, Hassan.
no, it's fine. Learned counsel for the petitioner and reporter. The petitioner is seeking regular bail under 483 in connection with GR case number 2778 of 2012. Within bracket, rising out of Sorbok PS case number 198 of 2012 under so and so section, bracket close, pending before the court of the learned JMFC Borpeta. At the stage of appearance.
Yes, my lord. Still not been committed, my lord.
At the stage of appearance and awaiting committal, full stop. It is stated and submitted that due to failure of the petitioner to appear, NBWA was issued on the strength of which he was arrested, and thereafter his good name is Bilal Hussain. On the strength of he was arrested and upon production remanded to judicial custody by order dated 14/5/2026. The learned counsel submits that the petitioner is facing another case being GR case number 2524 of 2012 before the
same court, my lord.
Before the same court, and in which he has been appearing regularly. However, due to some communication gap with the engaged counsel in the present case, that is GR number 2778 of 2012, he failed to appear on some dates, pursuant to which the warrant came to be issued, resulting in his arrest and subsequent and present custody. Full stop. It is submitted on behalf of the petitioner that he shall appear that he has no intention of absconding and that he shall appear before the learned court below and cooperate with the trial. Full stop. He is in custody, as mentioned above, he is in custody since
13/5/2020.
13/5/2026.
Yes, ma'am.
13/5/2026. Full stop. Also heard the learned additional people. Full stop. Peruse the relevant materials. Full stop. In the given facts and circumstances, the petitioner, Sir Bilal Hussain, is allowed to go on bail, regular bail of rupees 50,000 on bail, on surety of the like amount to the satisfaction of the learned JMFC Barpeta, subject to the condition that he shall appear before the learned court below on next and subsequent dates. He shall be available for the trial if one commences. And number 3, he shall not hamper or temper defense. Violation of the bail conditions would make the bail liable to be cancelled. Bail petition stands allowed and disposed of. Okay, disposed of.
In that case also, my lord, in that, my lord, in 2524, 2002, he has stated that he, my lord, appeared regularly in that case. But from page 48 only, that in one occasion, my lord, 2 occasion, he submitted my lord, adjournment petition. Otherwise, his appearance, my lord, nowhere reflected.
My lord, Annexer 10, my lord, 15C, order dated 15/6/2016, my lord. Where, my lord, it is on that day I was allowed to go on bail, my lord. Sir, 10, my lord, page 46.
In 16, my lord, he was allowed to go on bail, but
Thereafter, he has appeared through counsel.
Yes, my lord. Otherwise,
I am appearing, my lord. Sometimes I
he has
appear
not
with the
only
counsel or
filed
represented by the
adjournment
counsel, my
petition.
lord.
Please appear and follow.
Appear,
I have gone by his undertaking.
my lord. My lord. Obliged, my lord.
May I please, your lordship. My lord, 483 application, my lord. FIR at page 26, my lord. In this case, my lord, the petitioner number 1 and petitioner number 2 are the husband and wife, my lord. The allegation is that they concealed their birth of child and they burnt the child, newborn child, my lord. The allegation, my lord. My lord, my humble prayer is that, my lord, the petitioner number 1, who is suffering from mental disease, my lord, and as per medical report, my lord, it is proved that she is medically unfit. Kindly may peruse at page 61, my lord. Page 61. Last paragraph, my lord.
Who lost the FIR?
FIR was lost by the neighbor people, my lord.
Villagers.
Yes, villagers, my lord.
51.
Page 61, last paragraph. Seen the compliance reports. My lord, beforehand, my lord, the learned trial court sought the report from the jail authority, and jail authority sought the report from the medical board, my lord. And accordingly, report was received by the department, and page 61, it is reflect that seen the compliance report submitted by Superintendent Jail District Jail Nalbari, filed letter number so and so, stating that letter has been sent to the Director of Social Justice and Empowerment Assam for providing psychiatric treatment to the accused Nasima Bibi on so and so, but no communication has been received from the Social Welfare, Social Justice and Empowerment Department in this regard. In view of the report of the Superintendent Jail District Jail, this case is postponed till recovery of the accused from illness. So the trial has been postponed, my lord.
With regard to her or with regard to the other person also?
For the petitioner number 1, Nasima Bibi, my lord. And my lord, page number 63, my lord. 63, para number 3rd, my lord. Report of medical board of accused Nasima Bibi has been received from the office of the Joint Director of Health Services, Nalbari. Right, letter number so and so, dated so and so. Keep the same with the case record. It is seen from the medical report that district standing medical board meeting was held at office of the Joint Director of Health Services, Nalbari, on so and so at 11 a.m. and they have examined accused Nasima Bibi. After examination of accused Nasima Bibi, the board had opined that Nasima Bibi has been suffering from major psychosis and undergoing treatment at District Jail Nalbari. The board further reported that as far insight and judgment are impaired, she is unable to understand allegation against her and its consequences. So accused Nasima Bibi is not fit for facing trial at present. I have heard learned counsel for the defenses as well as the learned PP of the state. After 64 million, after perusal of the entire documents on record and also considering the submission made by both the parties, I deem it fit to postpone the trial of the accused Nasima Bibi till the accused is fit enough to face trial. In view of the above, further proceeding against the accused Nasima Bibi is hereby postponed till her recovery from the illness. So, my lord, the case against accused number 2, charge has been framed.
Right.
But against accused number 1, charge has not been framed. Against her, the case is postponed till her recovery of the medical fitness. My lord.
Right.
Okay. So in this regard, my lord, I may be allowed to go on bail. And on the other hand, my lord, in regard to the petitioner number 2, when the accident occurred, my lord, at that moment, my lord, he was not present at the residence, my lord. He was in the market, my lord. And it is proved from the statement of their son, my lord. Of 18-year son, his statement has been recorded. And in the statement, it is says that as and while the incident occurred, his father was in the market and went for bringing clothes for the newborn baby. And this accident maybe happened, my lord, due to the mental disease of the petitioner number 1, mother of the deceased, my lord.
Very detailed order, by.
And we are behind our more than 260 days, my lord.
Please, Lordship. In this case, the main problem is that, Lordship, there are two, their own children, son and daughter, both are the witnesses in this case, Lordship. Until and unless they are not being examined, they may be influenced, Lordship, at that any time, Lordship. And
But I think we should consider for her because her
Lordship,
trial is postponed.
if she is
She's suffering from psychosis, and so but she has to take treatment. That is the thing. But keeping her in detention is also
the jail authority may be directed to give her proper treatment, Lordship, because, Lordship, if she is being released on bail, Lordship, and in that moment, Lordship, those two children, they are also in danger. They will also be in danger because, Lordship, she has the history. In this case, Lordship, she when she herself was killed a child, burned a child, Lordship, on the same day, Lordship, he along with his husband, Lordship, then what can she do to that those two witnesses, Lordship, that her own
they are not they are minor. They are not minors. They grown up.
they are not
18 years.
minor, but Lordship, that can
But
be done.
how was the Azhar? I just want to see.
And apart from this,
This is
Lordship,
the victim.
there is, Lordship, in page 69, Lordship, the trial court order, Lordship, there is, Lordship, fourthly, Lordship,
10.5 years.
these persons, the accused person number 2, Lordship, that is, Lordship, the husband, Lordship, he also tried to escape, Lordship, earlier, Lordship, tried to flee, Lordship.
Iqbal, Ayam Ali. Their
Lordship,
5
at this
brothers
stage,
and
Lordship,
sister.
persons,
being
custody should be required, Lordship, because, Lordship,
in relation.
will get better treatment, Lordship, if she is in custody and the jail authority can give her. That may be direction, there may be a direction to the jail authority, Lordship. And because unless and until if she comes out, then the cases are in danger, Lordship. If she is her mental state is in like that, Lordship, that she can kill anyone, she can.
No, actually, such kind of violent behavior is alleged against the father by the child,
Her also, Lordship.
by his son, who was aged 18.5 years. He said about
But
that her mental problem started when he started hitting his mother on the head.
That is true, Lordship. That father hits her mother, that is why her mental condition like that. But what she done, Lordship? Immediately on the same day when she gave birth to his child, Lordship, she killed her, Lordship. She burned her, Lordship.
It may not be,
Lordship,
in
how
the right frame of mind, actually. That is also maybe true. But somehow I am inclined to grant her bail and hold it for Ayam Ali for some time. So, because, but the only thing is that my only concern is that that if she just disappears and then because she's facing a trial, that is a reality. So she has to take it is under suspension because of her mental condition. So the mental condition has to be evaluated from time to time. So that if she regains her mental condition, then the trial will resume. So you can suggest suitable conditions on those lines. Anyway, because it is recorded by the court that she's,
Instead of her, that if Lordship is willing to release her, then instead of releasing her directly to, but that she may be sent to the the Lordship may release on bail, but proper treatment in she may be given to the any mental health mental hospital. Or
direction to whom? That is what I'm saying. Whom? Who will take, because suppose she's sent to that our regional institute in Tezpur, then because I have this practical experience, so that if a person is in custody, then someone from the jail will have to keep waiting there. A big logistics problem. And if she is released from bail, then the jail authorities, they have already enough pardons. They will wash their hands off. Then they will not send anyone. She has to go alone. If he's under treatment through the jail, then they'll have to keep someone there permanently till she's there.
Someone has
So
to
this
take
is
her
the practical
custody also.
difficulty.
Someone has to take her custody also in that case, Lordship. If she is not mentally fit, leaving her, leave her.
Will she get a surety? Can she get a surety?
My lord, she has the children and parents also, my lord. My lord,
Her
guardian
parents
is
may be
there, my
there.
lord. They will take over the.
And will
But this father should not be.
not now. Not now. Hard. It is revealed from the records that the two petitioners here who are husband and wife are facing trial in sessions case number 41 of 26 pending before the learned sessions court Nalbari. Within bracket arising full stop. The gist of the allegations in the FIR is that the petitioners in furtherance of their common intention kill their newborn infant by burning and conceal the body in a jungle. So subsequently recovered. The learned counsel has taken the court through the relevant orders passed by the learned trial judge. While charges have been framed against petitioner number 2, medical report was called for with regard to the mental health condition of the petitioner number 1. And she was also subjected to such medical examination before a board. Full stop. As reflected in order dated 8/6/2026, the medical board had opined that she was suffering from major psychosis and undergoing treatment. But she is undergoing treatment in the district jail. This is also there. Undergoing treatment in district jail Nalbari. It is reflected in the order that as per the report, her insight and judgment are impaired and she is unable to understand the allegations and its consequences. Full stop. The learned trial court opining that at this stage the petitioner number 1 is accused is not fit to face the trial has postponed her trial while proceeding against the petitioner number 2. The learned additional PP has expressed the concern that the learned additional PP, while opposing the bail of both the petitioners, it has expressed concern that in case the petitioner number 1 is released on bail on account of her health condition, there might be influence or intimidation of their children They are teenage children who are witnesses, important witnesses in the trial. So I have given my consideration to the matter and peruse the materials available at this stage. Stop. It is necessary for the petitioner number 1 to continue her treatment to address her mental health condition, subject to the said aspect. Stop. It might be desirable to release her on bail rather than keep her in detention. Keep her in detention. Accordingly, the given facts and circumstances, the bail petition of petitioner number 2 stands rejected at this stage. Full stop. However, at this stage, however, petitioner number 1, namely Nasima Bibi, is hereby allowed to go on bail of rupees 25,000 with 1 surety of the like amount, the satisfaction of the learned Session Judge Nalbari. The following conditions are imposed. You can suggest one.
Our family members should be not as a
She shall not abscond. She shall not hamper or tamper with witnesses and shall not intimidate any witnesses, including her children. Her close family members, full stop. Well, can you suggest what can we can
if 2 bailers may be given, or one of the bailers should be from her relatives or
family
members.
Is it okay?
Because Lordship, if some other outsiders have come
With 25, make it 20,000 with 2 sureties of the like amount. One of the sureties should be family member. No, all conditions all that. The petitioner shall continue taking her mental health treatment to address her mental condition, so that she becomes fit to, so that she becomes fit enough for resumption of the trial with regard to her. The surety can give an undertaking in that regard. Can they? They can. For the said purpose, the second surety, who has to be a family member, close family member or close family member, shall give an undertaking before the learned trial court in this regard. This should not be a problem. It is for our best interest. The bail petition stands partly allowed and disposed of in the aforesaid terms.
Highly obliged, my lord.
Lord, in this case, my lord, the petitioner's wife died due to an unfortunate incident, my lord, and thereafter, the FIR was filed lodged on 21st of February 2026. Thereafter, on 22nd of February, he was arrested, and for the last 187 days, he is behind the bars, my lord. The charge sheet has been submitted, that is on page 27, on 11th of May. And although trial has commenced, but evidence stage has not started, my lord. And the postmortem report, if my lord may kindly peruse page.
He is the husband.
I'm the husband, my lord. Page 26, my lord. The cause of death is still kept pending. Page 26, number 1.
subsequently
The opinion regarding the cause of death is kept pending until the receipt of the chemical analysis report. I'm behind bars for 187 days, my lord. More than 6 months, my lord. And The next date is tomorrow, my lord, for the witnesses have not turned up. They have sending summons.
It is alleged to be suicide.
Yes, my lord.
Search file lordship on 80 BNS lordship. 82 BNS.
80. It is
80, that is
80 subsection 2.
dowry debt. Read it.
In that view of the matter, I'll face the trial, my lord. There are only 9 witnesses. And also it will take some time, my lord, because the witnesses are not turning up. I have the copy of the last order, my lord. The witnesses have not turned up, my lord.
Charge frame on lordship 21/7/26 lordship. 9 witnesses are dear lordship. No witnesses still get examined lordship.
Nine witnesses. How many examined?
Listed witnesses, not
No.
terms. One thing is that lordship, the vital witnesses are from the family members of the this lordship. Others, some witnesses are dear lordship as per the even 183 81 statement lordship, but those are lordship some reported, not the.
Okay. No injuries were found on the body, but neck, this.
Page 23, my lord. No injuries, my lord. And there is no act of violence, my lord. It doesn't indicate anything.
Dowry, the allegation is that due to torture and all, she.
Is dear lordship. From the complaint.
We'll face the trial. I've made a statement that I'll face the trial, my lord.
Additional people. The brother of the deceased lodged an FIR dated 21/2/2026. The allegations that his sister was married with the present petitioner Rintu Das, and after her marriage, he was subjected to dowry demands, and also subjected to dowry demands, and physically and mentally tortured, eventually leading to her suicide. The investigation resulted in a charge sheet, and subsequently, where's the charge framing order? Charges were framed.
Charge frame.
How many accused persons were
Only one. They are against only one. Only one.
Charge has been framed against the petitioner under section 80.
80 subsection 2.
80 subsection 2 of BNS pertaining to dowry debt. Stop. Fight order dated. I've seen the order, charge framing order.
You got it. Order dated 21/7/26.
21/7/2026.
Page 40.
It appears that so far prosecution evidence has not started. The accused is stated to have been arrested soon after the lodging of the FIR on, when was he arrested?
22nd February 2026.
22/2/2026, and since then he's in custody. He's in under trial detention. Only 6 witnesses. Nine witnesses are listed in the charge sheet. Considering the length of detention and the stage of the case, I had a language just like that. The postmortem report does not reveal injuries on her body or private parts. However, DHO marks were found on her neck, and she was also found to be carrying pregnancy at the time of her death. Next paragraph. Considering the length of the under trial detention and the stage of the case, I am of the considered view that the petitioner can be granted bail at this stage, subject to suitable conditions. Accordingly, 50,000. Satisfaction of which court?
Additional District and Session Judge Dibrugarh.
Learned trial court. Following conditions, he shall be available for the trial. Number 2, he shall not hamper or tamper with evidence. He shall not in any manner cause any threat or intimidation or harm upon the informant and his family members. In case of violation of the bail conditions, the bail would be liability cancelled. Allowed and disposal.
That's all.
Perus can TCR to me. Timing is not 38.
May it please your lordship. My lord, regular bail application, your lordship. Petitioner was arrested on 8/8/2026, your lordship, as on 21 days, your lordship. So allegation in a nutshell, your lordship. And unfortunately, your lordship, Dr. Virla accident had taken place, your lordship, where the accused petitioner have been implicated, your lordship, that due to his rash and negligent driving, accident had taken place, your lordship. Actually, the actual facts of the case is that on the date of incident, I'm the, your lordship, owner of the Bolero vehicle, your lordship. On the day of incident, your lordship, I was going to Nagaon from Gauhati, your lordship. So on the way at 37th National Highway, your lordship, so there was a divider and U-turn, your lordship. So suddenly the scooty rider, your lordship, so sustained grievous injury and subsequently brought death. So he suddenly take turn, your lordship. So in spite of my due diligence, caution, care, your lordship, it could not be prevented, your lordship. So there is no rash and negligent driving, and more so, your lordship, 1 month baby, my wife already given birth, a child 1 month, as it about 1 month, your lordship. So his presence at this juncture is very much crucial, your lordship.
Tragic incident.
Appears to be an accident more or
Yes.
some kind of homicidal.
Homicide.
See, we have discussed this also, and okay, I think we can allow that judgment.
Regarding
There are 2-3 other judgments also, but Pereira, they explain that sometimes if my negligence is so high that it can cross it has used the expression in the judgment also I've seen, can cross the domain of only negligence and cross over into homicide with knowledge. I'll give you an example. Suppose at 10 a.m., in this road, before Handy College or Cotton College, I'm driving a car with 100 speed. So obviously I'll be attributed, I'll kill someone. It's very likely that that person will kill someone. So he can be attributed with almost homicidal negligence, if you
Here
can
in
use
this
that.
case, it seems that accident occurred in the national highway. National highway in Khetri area, U-turn is there. Yes, in that U-turn, he is the driver of that Bolero vehicle. That Bolero vehicle was also at that point of time he was moving from Gauhati towards
Has been high speed also.
high speed also. Regarding that statement of witnesses also there, witnesses stated that he was in a very high speed and in a race and negligent in a carelessly he was driving the vehicle in a very high speed, and because of that this accident occurred, and ultimately one is 28 years and one is 5 years old, and informant is the husband of the.
Give me the.
Yes.
There are people driving the highways are very fast. Actually, our 4 lanes are not meant for so much high speed, though it is 4 lane, because there are so many
Regarding speed,
blockages. People come from the opposite side sometimes. 100 speed is actually not safe for a high. So it's 580, maximum 80, in my opinion. These are not barricaded highways. আগৰটোৰ পৰা এইখিনি লৈ ল'ব পাৰোঁ, মিষ্টাৰ দিৱান এণ্ড পি বৰঠাকুৰ লিখা আছে মোৰ। The learned counsel submits that despite taking precautions, the incident took place and he is in no way responsible for any criminal negligence or knowledge of causing death in the unfortunate incident. So it is also submitted that wife of the petitioner has recently gave birth to a child, and for which he needs to be nearer his family. The learned additional PP submits that it is revealed from the mouth of some of the witnesses that the vehicle was in high speed at the relevant time. Nevertheless, considering the facts and circumstances, the progress of investigation and length of detention, the petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the concerned learned court, which will be CJM Kamrup Metro. Concerned learned court, CJM Metro.
Yes.
And subject to the conditions that he shall cooperate with remaining investigation and shall not hamper or temper it with its return case diary. Bail petition stands allowed and discussed.
May it please the Lord. Not regular bail application, my lord. 51 days in custody. This matter, my lord, last came up on Tuesday, my lord. Lordship may remember the FIR, my lord, at page number 27. The victim, my lord, who was with his wife, my lord, he had taken some spurious substance, my lord.
No.
That's kind of energy stimulation, my lord.
Right.
And then, my lord, he had to be admitted to
Okay.
the hospital. At page number 27.
Got it.
Yes. So, he was admitted to the hospital, my lord, on 7/2/2026, my lord. Thereafter, my lord, he was discharged on 11
Yes,
to
yes.
2026.
When he became sick. So what does investigation say? Any
Yes.
foul play?
Yes, just one thing, my lord, I'd like to highlight, my lord. The thing is that after, my lord, the incident took place, my lord, that is after his death, they did not immediately lodge any FIR. They, my lord, gives this information. Lordship will kindly have a look at page number
After 6
33.
days. UD.
UD, which was registered as an UD case, my lord. Now, Lordship may examine, my lord, whether this present FIR is maintainable, my lord, because it does not reveal any new set of facts, my lord, which were discovered
UD
later. my lord.
cases usually get merged, right?
Yes. Whatever, my lord, was alleged in the present FIR, my lord, already were there before the UD case was lodged, my lord. Just, my lord, their only ground is that, my lord, the FSL report in the UD case was delayed. That is why, my lord, they lodged this present FIR, my lord.
Yes. Tell me.
Yeah, my case they received, my lord. Regarding maintainable, that will not come because my lord, subsequent FIR will merge with the UD case, my lord. And regarding, my lord, here, yes, in this case, my lord, initially, my lord, that incident occurred on, my lord, 6/2/2026, my lord. On that particular day, my lord, the present accused is the, my lord, brother-in-law of the deceased, my lord. And on that day, my lord, as per the allegation that, my lord, these accused persons, my lord, tortured the victim, and thereafter, my lord, that on that basis, my lord, initially that on 6/2/26 at around 7 p.m. in the evening, my lord, the deceased went to the residence of his father-in-law's house, that is the house of the, my lord, present accused persons, my lord. On that day, this entire incident occurred, and regarding that, on, my lord, 12/2/2026, after his death, my lord, that is, he was expired on.
the wife of the deceased is the sister of the
Yes,
accused,
yes.
sister of the accused.
The
There was some
present-
there was some dispute between them, husband wife.
Dispute between husband and the, my lord, deceased, wife and the, my lord, that is, my lord, accused number one. Accused number one in the affair, my lord.
Her brother, it means.
Yes, her brother, my lord. The present petitioner is her brother, my lord. An allegation against all the accused persons, and here, my lord, I have also received the on thereafter on 7/2/26, my lord, immediately after incident, he was, my lord, taken to the Lakshmipur hospital, then thereafter Gwalpara, and thereafter again in Metro hospital. He was
Why was he why was he assaulted? If it is there in the
assaulted, my lord, regarding that
any motive?
some photographs is here in the FIR, my lord. But regarding that, my lord, in the PM report, an inquest report, my lord, regarding injury, I have not found anything regarding that. But some photographs, he was, my lord, injury in his butt, my lord. Regarding that one photograph is available in the CD, my lord. And ultimately, my lord, I have also received the final opinion regarding the cause of death, my lord. And the cause of death is, my lord, Shafirul Alam was due to organophosphorus insecticide poisoning. So there are allegation is also that on that particular day, my lord, these accused persons, my lord, administered some something for which ultimately
He died of poisoning.
these are some. So the lordship may kindly peruse the.
What is your instruction? I mean, some dispute, family dispute.
Family dispute may have been there, but at the when he was with the in the company of his wife, the entire incident took place, my lord. Now, my lord, they are living separately, my lord. He's a brother-in-law, my lord, the brother of the wife and the brother.
That day, wife was also in the house. Wife was also in the place of occurrence.
Wife was with the deceased, my lord, at that point of time.
And the place of occurrence.
At the place of occurrence, my lord. And my lord, whether those injuries, my lord, those injuries were there only, my lord, before the UD case was lodged, my lord. Why those things were not brought to the knowledge?
When was he
of the police,
arrested?
my lord?
When was he arrested?
There was allegation in the FIR, and most of the time, wife is, my lord, living in her, my lord,
Maternal house.
maternal house. Thereafter, on that particular day, on 6/2/26, my lord, the present deceased, my lord, also went there, my lord.
He was arrested
To, my lord, inquire about his, my lord, wife and
on 8th of July, my
his daughter, my lord. And there, my lord, that incident occurred, my lord. Although, my lord, statement of the accused is not admissible, otherwise also, then also your lordship may kindly. I have flag marked, my lord, the final report regarding final cause of death, PM report. Who dropped some injury marks there, but my lord.
There was dispute between the husband and wife. So also
Regarding that aspect also witnesses. That is the statement of the accused. Otherwise, my lord, some photograph is also there, my lord, regarding injury. But in the PM report, my lord, I find it difficult to ascertain.
PM report perhaps does not show anything about injury, my lord.
Statement is not admissible, but he has stated like that.
My lord.
That there was a heated argument because of his
And
conflict
regarding-
with his sister, and then we poisoned him. He said like that. Then after poisoning, they got scared and then took him to hospital. That not admissible, of course. This is a bail objection. You are for the informant. You have appeared today? You have appeared today?
ANS offense, my lord, injury report reveals that, my lord, they are intentionally tortured and committed murder. My lord.
Just a minute.
And thereafter, my lord,
Let me go to the IO's narration.
report about that. Yeah, my lord.
All right. This is the prosecution. Now I'll hear you.
Some photographs, my lord, for injury, my lord. It reveals that, my lord, this is
Where is the photo? Sorry. You can submit, Mr. Islam.
my lord, on 18/8/2026, my lord, one complaint has been filed before the superintendent of police as well as to the deputy commissioner of the concerned district, my lord, regarding, my lord, that the informant is pretending to withdraw this FIR, my lord. Otherwise, he will kill him also. So, my lord, at this stage, my lord, my humble prayer, this is absolutely heinous offense. The photograph reveals that, my lord. So, the bail may be rejected, my lord. Otherwise, the investigating agency will be hampered, my lord.
You assaulted, it seems. These are the photographs.
The reply, my lord, may I submit, my lord?
Yes.
Three things, my lord. First thing is that, my lord, if he had indeed in his 161 statement, my lord, before the police has accepted his guilt, my lord, whether, my lord, the IO had taken any steps for recording his confessional statement, my lord. If not, why? One question, my lord. Next thing is that, my lord, these photographs, my lord, were already there with them, my lord. Why they did not submit that to the police, my lord, when the UD case was lodged, my lord? They did not. And, my lord, the postmortem also, my lord, does not suggest any injury, my lord, internal or external, my lord, nothing. And third thing is that, madam, without even going to a merit, madam, he has completed 51 days in custody, madam, whether further detention is required or not, madam, for the purpose of investigation, madam. I'm not for the wife, madam, only for the brother-in-law who resides separately, madam. It has nothing to do with the domestic dispute between the husband and wife, madam. Lordship will consider, madam.
Except the petitioner, my lord, the other accused are not arrested yet, my lord. Mainly military here in the army.
Your file is complete before SP.
SP as well as the
bring-
concern. DC.
Anyway, sit down. Take some time. Third, Mr. S. Das, learned counsel for the petitioner. To P. Botakur, learned additional PP for the state, and B. Islam, learned counsel was appeared for the informant. Stop. The petitioner, namely Nur Hussain, alias so-and-so, is seeking regular bail under 483 BNSS in connection with Fakirganj PS case number 77 of 2026. And so section. Full stop. On 12/2/2026, information was lost by one Moidul Islam before the Fakirganj PS. The allegation that the allegation is stating that on 6/2/2026, his brother Safiur Rahman, within bracket, deceased, had gone to his in-laws place. But later he fell sick and was admitted to Metro Hospital. Full stop. He was brought back to the residence on 10/2/2026, but soon after, he again became serious, due to which he was taken to Gwalpara Soles Hospital. But he died there. Based on the information, UD case number 5 of 2026 was registered. Subsequently, it appears that the informant side was not very satisfied with the non-completion of investigation in the UD case, and they lodged a complaint dated 4/7/2026 before the same police station, naming 8 accused persons and other unnamed others. Full stop. The present petitioner is mentioned as A3 in the FIR. Full stop. The gist of the allegations is that the deceased was married to the petitioner's sister, had visited his in-law's place on that day, but he was subjected to torture and poisoning. Subsequently, he died. Full stop. The Mr. Das, learned counsel for the petitioner, submits that the FIR was filed several months after the filing of the complaint, resulting in the registration of the UD case, and contents as to whether the subsequent FIR would be maintainable. It is also submitted that the petitioner was arrested on 8/7/2026 and has been in under trial detention for more than 2 months. About 2 months. About 2 months. Full stop. The case diary was called for and has been received along with a bail objection. The learned additional PP, Mr. Borthakur, submits that as per the opinion regarding that the deceased died of poisoning due to organophosphorus. Full stop. Should because photographs are not in the CD, right? It was prosecution is also drawn attention of the court to certain photographs which were collected during the investigation and submits that the same reveal signs of torture upon the victim. Stop. The learned counsel for the informant, B. Islam, submits that the accused persons are responsible for committing a heinous crime of pre-planned murder of the victim after torturing and poisoning him, and that the informant side are the risk of facing threats from the side of the accused, and that bail at this stage would prejudice them. I have carefully gone through the detailed bail objection submitted by the investigating officer. The IO has contended that while there has been some progress in investigation, but important aspects are still being looked into and investigated, and leads are being looked into and explored. Stop. The contention of the IO in the bail objection is that investigation is at a crucial stage, and granting of bail at this stage might prejudice the investigation, might hamper the investigation. I've given my consideration to the materials, the submissions, also to the contentions of the IO. Peru's statements of some of the witnesses flagged by the learned additional people. The given facts and circumstances, I am of the considered view that would be prudent refuse the bail for the moment, while the investigation is still proceeding. So in such view of the matter, the bail petition stands rejected at this stage. Return the case diary. Okay. Yes.
Deep blue.
This was mentioned in the morning. The 51 was mentioned, but it's a connected application. Do you remember the date which we fixed? Diary had come.
No, CD not received.
Not come. The connected bail application within bracket AB 1185/2026 was mentioned in the morning, and it's fixed on 9/9/2026. None appears on call at this hour. The case diary is also not received. Issue fresh requisition for the same. Fixed on 9/9/2026, along with the aforementioned connected bail application. Okay, you are for the informant. Okay, I'll record your name, learned counsel. appears for the informant side.
Number 58, my lord,
With the orders.
interim is there, my lord, petitioner appeared statement recorded.
Yes.
In item number 58, my lord, petitioner's interim is there, my lord. He appears statement recorded.
Cooperating with the investigation.
We can take it from the order.
Regarding
21.
farm is superhuman. He is the owner of that godown.
The petitioner was granted interim bail by order dated 21/7/2026. Upper part you take from here. Full stop. With conditions. The case diary has been received. Learned additional PP submits that the petitioner has appeared before the IO, rendered his cooperation, and his statement has been recorded. The investigation has also progressed. In the circumstances, there's no necessity for cancelling the interim pre-arrest bail, which accordingly is made absolute, subject to the condition that he will render cooperation to remaining investigation and shall not hamper or tamper it. Return case diary locked.
Obliged, Lord, sir.
Yes.
May I please to Lordship, matter may be adjourned for the day, Lordship. Engage counsel, Mr. Aramin. Out of
We have received a case drive also.
You don't want to do it today?
He was there. Next week, I get.
The, yeah, just a minute. Learned counsel appearing for the petitioner prays for taking up the matter on another day. Petitioner was granted interim bail with conditions on 7/8/2026. He has appeared.
Appeared and statement recorded also.
We'll make it absolute then.
Tension betting at Gauhati.
Tir. Tir.
That's IPL betting.
IPL betting.
Our accounts were used as per the amounts. Accused is different also.
Achha. Our account was used.
Yes, sir.
Amida. The case diary has been received. The learned additional PP submits that pursuant to grant of interim, the petitioner has appeared before the IO and our statement has been recorded. Full stop. It is submitted by prosecution that the thrust of the allegation against the present petitioner is that how her account was used for
ATM cards were used for transferring the amounts.
for transferring money pertaining to the IPL betting
By the main accused.
by the main accused. In the context of the fact that the petitioner has rendered her cooperation to the investigation, her interim can be made absolute. Accordingly, the interim bail so-and-so is made absolute, subject to the condition that she shall cooperate with the remaining investigation, shall not commit any illegal activities or offences, including any activities prohibited by the Assam Game and Betting Act. Also. Your good name?
SM Jinnah.
Yes, okay.
SM Jinnah.
Okay. Then no need to listen. You write there, here, it's there.
I'm on behalf of Aramin.
No problem. Bail petition is allowed and disposed of. Return the case there.
Gotcha.
Okay.
SK Ramoto. Aramin and Ramoto.
Wait. The report was called for whether there is any FIR registered, my lords.
Okay.
No any case found registered against one petitioner lordship.
No case.
No case. Let it dispose of.
Mr. Ganguly, learned counsel for the petitioner, and DP Goswami. Can you give me the report?
Yes.
Pursuant to order dated 10/8, 10/8/2026, a report was called for from the, which police station this one?
Dhula.
Hmm?
Dhula in Dorong district.
Huh?
In Dorong district.
Okay. Dhula, Dhula PS. And accordingly, the learned public prosecutor, additional public prosecutor, submitted the report dated 18/8/2026 received from the OC of Dhula Police Station in the district of Dorong, stating that as per the PS records, no cases registered against the petitioner Ranjan Kellen till date at the said police station. Full stop. In view of the said report, the present petition would not be maintainable and is accordingly disposed of. Needless to say that if the petitioner has any bona fide apprehension of arrest in the future due to any relevant facts and circumstances, he would be at liberty to take recourse to the remedies provided by law.
The report is kept as a part of record.
The report shall be kept as part of the record.
61.
We have not received a case diary.
Okay.
Please. They have already also filed an additional affidavit on 26.
That is on record.
So it has not come in.
It has not come to record. You are Miss N. Burman, N. Kashyap, and counsel. Case diary is not received. Issue reminder for the same. Full stop. It is submitted by Ms. Kashyap that the petitioner has filed an additional affidavit which has not yet come into the record. The same may be brought into the record. Full stop. What is the allegation?
Section 69 BNS.
Suicide. Get the case diary.
A fixed date may be given.
Yes.
13th of
You want it, is it okay or you want it earlier? 13th is holiday.
13th.
No, it's 13th is Sunday.
14.
Sunday.
Holiday 14th.
Is it okay or you want it earlier?
If possible, an earlier date may be
Earlier
given.
date.
9 or 10.
9.
Much obliged.
Please, Your Honor. A report was called for from the civil, called for, but
It is not received, Lordship.
on 17/7/2026, police visited from the Sirumi police station my house when I was not present, Your Honor. They informed that one Sweetie Chakraborty lodged and complaint in their police station, but that this did not disclose any case, and they have even not issued any notice to us, but they over telephone asked me to appear before the police. I am a private company employee, Your Honor. I am manager of Asgard Labs Private Limited, Your Honor. So I have every apprehension that I may be arrested by the police. My old age mother, 72 years, is living alone in my home, Your Honor.
You're Mr. New,
Your Honor.
learned counsel for the petitioner, and P.P. Goswami. The petitioner has filed this pre-arrest bail application under 482 BNSS with apprehension of arrest on the basis of a complaint purportedly filed by one Miss P.T. Chakraborty. Full stop. However, he does not have details of the case, though he has been summoned by the Tribhumi PS. Right?
But over phone.
Over for telephonically. Full stop. Report was called for, but same is not received today. issue reminder for the report. Full stop. Further, till the returnable date, the petitioner shall not be subjected to any coercive action. Subject to the condition that if the case has been registered and investigation is on, the petitioner shall render cooperation to the same.
Master.
List on 15.
Master.
Here, your lordship will find page 8. There are 5 persons are named in the FIR. Lordship, I kindly say page 9 first, just one petitioner before your lordship.
Okay.
It's 9. Page 9, 5 persons are named. One Joliluddin is named, son of unknown. And perhaps because of that, the police is searching me, Lordship, that Abdul Jalil. I am Abdul Jalil.
Lot of these allegations are a little peculiar and a
Yes.
bit serious actually.
This one is mainly against accused number 1. And in fact, Lordship, I have stated in my petition also that he is even ready and willing to conduct DNA test also.
That is a sign of confidence.
Yes, the paragraph
That
4
is
I have.
good actually. If someone is falsely implicated, he should come forward and say
Yes.
that, you know.
He will
Do a
appear
DNA
for the
test.
investigating officer, he will cooperate for DNA test also. That is paragraph 4 I have stated, Lordship. Paragraph 4,
I have
last
noticed
3
it.
lines here, Lordship will find.
Mhm. What do you say, Mr. Goswami?
For a 183 statement, the victim has seen that her husband is out of the state for work purpose for last 5 years. And from last 4 years, she unable to come to the state. That's why these 5 persons were taking the chance advantage of this representing the lordship. They are left her. Some Mustaquddin, he has implicated, some Masukuddin, one is Selimuddin. About this petitioner, his name is, he has stated that Joliluddin is there, but where his petitioner's name is Abdul Jalil.
Abdul Jalil.
Abdul Jalil is Joliluddin. For her statement, Joliluddin is here also.
Father's name is also not given.
Yes.
So he can get some benefit probably. Otherwise,
In fact, I have
so
also said.
pregnancy is different. I mean, but
That is different, but,
still a person may be involved.
FIR said she is carrying pregnancy of 7 months, so that I have stated that.
So pregnancy, I mean, maybe due to some other person, one of the other accused.
Yes, at least 5 persons.
5%.
Yes.
What to do then? But
then-
but there is a name discrepancy.
Yes.
Name discrepancy is there.
Yes, stated Joliluddin, but his petitioner's name is Abdul Jalil. The
Son
FIR.
of Farizuddin.
Yes. But his house is searched.
A. Ahmed, learned counsel for the petitioner, and D.P. Goswami. The petitioner is seeking anticipatory bail in connection with Lanka PS case number 179 of 26. And you write the name, petitioner, namely Abdul Jalil. That's also. FIR dated 8/8/26 is lost by the father of the alleged victim woman. The allegation that her husband stays far away and she lives alone with her child and suffers from mental illness. That taking advantage of the same, the accused number 1 of the FIR established relations with her, resulting in pregnancy, which was subsequently terminated. It is further alleged that after the incident, the accused number 1 sent the remaining remaining four accused, and they also established physical relationship with the victim girl, leading to another pregnancy. One, Jaliluddin, son of unknown, is mentioned as A5 in the FIR. It is Mr. Ahmed, some learned counsel submits that the petitioner is Abdul Jalil and he is not at all involved in the incident. Drawing attention to para 4, the learned counsel submits that the petitioner seeks to render cooperation to the investigation and also undergo a DNA test if necessary. It is submitted that he has been falsely implicated. The case diary, next paragraph, the case diary has been received, and after going through the same, the learned additional PP, Mr. Goswami submits that the petitioner, the victim has implicated the A1 and said that other persons have also exploited her. It is submitted that she has mentioned about one Jaliluddin, which name is also stated in the FIR. Next paragraph. The petitioner is stated to be the son of one Farijuddin. Next paragraph. Considering the contentions of the petitioner and also an aspect of discrepancy of name, his contention about being given a chance to cooperate with the investigation can be accepted. In such view of the matter, I allow this bail petition, and accordingly it is directed that you give it for 50,000 with 1 security. Satisfaction of the arresting authority. Number 1, he shall render his cooperation, investigation, appear before the IO, making himself available for examination. Number 3, shall not hamper or tamper with evidence, shall not commit any illegal activities or offences, shall not in any manner intimidate, harass, or harm the victim woman in any manner. Next, violation of the bail conditions would lead to cancellation of the bail. Return CD, bail petition is allowed.
Lord.
64 also here.
Best reader losses. That a missing FIR was lodged by the informant that I have kidnapped her minor daughter aged about my lord 15 years. Did was called for my lord?
He received lordship, here lordship, later on section 4 of POCSO is added.
POCSO is
added lordship.
Later on added my lord. Because it is a my lord, love affair between the victim girl and the petitioner, my lord. He is the 18 years old boy, my lord. He is appearing in the higher secondary classes, my lord.
He or she?
He, my lord. The petitioner is my lord.
No, I'm saying that the who's 18 years? Victim?
17.
Victim or the petitioner?
Petitioner is 18 years, my lord.
18 years.
Is pursuing her higher secondary classes, my lord. At this stage, my lord, may I pray for some interim, my lord, because my exam is going on, my lord. The exam schedule is, I have a NSS page 19, my lord. At this stage, my lord, I will take steps on the informant, my lord.
What does it indicate? Elopement?
Elopement in relationship.
164 statement?
Yes, once as per the statements, they were on relationship. After that, they eloped. Her lordship going for statements.
Where is the exam schedule?
Page 19, my lord. Type copy, my lord.
Got it. Today also there was some exam.
My lord. But that I can, my lord, at least appear in on 29/8, my lord. At least one exam, my lord.
It's come from like this.
Yes.
Now what to do about the notice? I'm inclined to give some interim, no problem.
Yes. But notice is.
But it'll, that
on-
question.
Yeah, POCSO is.
That's why I've been telling, actually, get it clarified. And I'm
It's
sure
not-
it should be allowed. There should be a provision for interim, granting
Yes,
interim.
that's it. Functional statement of the victim guard.
But it needs to
That's
be
it.
clarified from the division bits by someone, by filing an IA in the
But-
disposed of.
But the POCSO matter activity, the notice should go first.
For appearing the exam valid at least for 1 day, my lord.
Then that's why I said no.
Yes, my lord.
I'm willing to give for the exam. Appears to be, she's a minor, but appears to be a case of elopement.
Yes.
But if it, I don't want to violate the order of the division beds. I have no right also. Only window you can give me is that it does not bar granting of interim. It does not say that would be a good advocacy's argument, but not judge's argument. I'm giving you the idea. Anyway, has he stated about relationship? Mr. Goswami, has he stated about relationship?
Yes.
POCSO was added.
Later on, I have flagged my lordship, trial court order was there.
Notice has to be issued actually. There's an element of force also.
Yes.
There's a small girl, minor. Anyway, he has not been arrested.
Maybe.
He has been appearing for the exams, so you can appear for the exams. You take the steps.
My lord.
Please take the steps.
Tomorrow I will take.
Mr. Bhuya, Land Counsel for the petitioner and DP Goswami. The case diary has been received. The case was originally registered under section 87 BNS, but subsequently, on the basis of the materials, the prayer of the IO for addition of section 4 of the POCSO Act was allowed by the learned court. I perused the statement of the victim girl recorded under section 164 CRPC. In the FIR, the girl is, the informant is indicated the victim girl to be aged about 15 years. Good stop. Since the case has been registered under POCSO Act, the petitioner shall take steps for issuance of notice upon the informant by as per the prescribed procedure. Is through the office of the public prosecutor. You retain the case diary?
If you leave it long,
What is the address? The case diary may be written. You kindly take the steps quickly, and then he can take instruction. After sending of the notice, the prosecution shall take instructions regarding such service. Okay, you take the instruction, then we'll take it up. Retain the case diary.
For exam, my lord, some protection, my lord.
For interim, I'm not inclined because the ingredients of POCSO prima facie are there. Hands are tied actually.
But then, my lord,
But he has not been arrested, no? So he has been appearing for the exams. He can appear.
because my lord, one problem is there, my lord, because informant is not made a party in this.
not implemented. So
Not
you have to be implemented first. Then I.
But my lord, as per order, I can take steps, my lord.
You can take steps.
My lord, duty of place, my lord.
The husband provides that.
Like short date may be fixed, my lord.
You take a date.
My lord.
You can take it early also, no problem. No, he has any other pending bails. Time being bail is there? Any time being bails? No, it would be a following. And some requests for upgradation also. But this is If 38 matter was there, Mr. Botago. Just a minute. Please take your seat. Our time being 9.
Wait, my lord, actually, in fact, IO stated that he tried to contact the informant, but he was not in the house. But through WhatsApp, my lord, he has already sent the notice to the informant. But till now, return message, my lord, he has not sent to the IO. My lord. Then he will have to receive that, and after receipt of that photograph of that, my lord.
We'll fix it.
Otherwise, IO has sent him to the through WhatsApp.
We'll fix it on first. The learned additional PP submits that he communicated with the IO of the case and has been informed that notice upon the informant has been sent by WhatsApp, but the response is awaited. So we fix another date.
Monday,
Second.
Tuesday.
This is the matter again on 2. What has come? Record has come.
Yes, CD received.
This is the matter on 2nd, 2/9.
Lordship, TCR also come, Lordship, and friend also appear for respondent. So, let's put the answer hearing.
Against conviction.
Against equity, Lordship.
Against equity.
And I actually, Lordship.
Heard Mr. A.K. Ahmed for the appellant, who's agreed by the judgment of acquittal in a proceeding pertaining to dishonor of checks. Learned counsel appears for respond number 2/ within bracket acquitted person. You are the complainant.
I'm the complainant.
The case records in original have been received from the learned court's bill. We'll fix it for hearing.
Yes, Lordship.
This is the matter, but it's a 26 matter. It will not come up. This is the matter and the hearing. When?
Second week of September, Lordship. He did.
Later.
Last week of September, Lordship. And
This is the matter and the last week of September on a date to be fixed by registry. They'll fix it.
May please, Your Lordship. Lordship, I am for the petitioner, and according to the order dated 3/8/26, steps has taken, Your Lordship. On
For delay condonation.
Yes, Your Honor. I is for delay condonation. Complete the legal hearing on record.
Delay condonation in filing a criminal appeal.
Yes, Your Honor.
Yes, ma'am. You are for?
Before, opponent number 1.
Respond number 1.
But my lord, his legal heirs did not contact me yet.
What is the appeal about? It is against conviction.
Against the acquittal, Your Lordship.
Against acquittal. You need some time to. Legal heirs means he's expired or what? PR Abdul Khalek.
Abdul Khalek
He has
expired.
expired.
Yes.
Oh, I see. Then you have to be substituted if you want to. Huh?
Steps has taken, Your Lordship.
Step second.
4/8/26 proceed.
Oh, अच्छा, this is no. You, Mr.
MUE.
Counsel, Madam.
R Begum.
R. Begum, not counsel for. Respond number one. First of the applicant is seeking to file a criminal appeal against acquittal, but there is a delay of 315 days for which an application under Section 5 of the Limitation Act has been preferred, whereupon IA Criminal 216 of 2026 has been registered. The second I is for substitution, the substitution one. However, the respond number one, PR Abdul Khalek within bracket the acquitted person is stated to have expired, leaving behind the legal heirs, likha ase naam, so and so. Notice another application has been filed for substitution of the legal heirs of the deceased, respond number one. Stop. Giving rise to IA Criminal 149 of 2026. Steps of notice have been taken upon the paid legal heirs. Stop. You take instructions, Ms. Begum, learned counsel, appearing for who had appeared on behalf of the private respondent, submits that he has to take instructions from the legal heirs sought to be substituted. There is no office note. I have list in the orders column on common order demo. Take it. When do you want it? After? You take a date. After 3 weeks. After 3 weeks. On a date to be fixed by registry. I didn't have the more break, no? Other books. But
Lordship, peruse the page number 21.
69. 69. This year received, my lord. May come up for admission, my lord.
Lordship, on last occasion, the court observed that after receiving the TCR, a prayer for interim shall be considered.
Just for that, my lord, matter may come up for admission, my lord.
For that, Lordship, even then total also it may be considered. What is the wrong there, as my friend is objecting? Lordship is issue.
you are seeking quashing of this case, right?
Yes.
Gauripur PS case number.
Yes.
So,
but if this cognizance is taken under section 153A and 295A, and for that the prior sanction of the prosecution is required, it is the requirement of the law as per section 196 of the CRPC. The issue is very simple. If there is a prior sanction, record shows my petition shall be dismissed, and if the record shows that there is no sanction was taken, prior sanction was taken before taking cognizance, then the petition shall be allowed.
295.
Yes. Cognizance is taken 295A, 153A, and
today, my lord, matter is received, my lord.
No.
Listed only for the.
Just having a look.
1961, Lordship, peruse that sanction is required.
Just one.
And there is a Katina decision passed by our court, Supreme Court, as well as various High Court, that if there is no prior sanction, the order of cognizance will go.
Okay, 295 is this. And where is the procedural provision regarding?
196. 196, Lordship. CRPC. Today I am not carrying this CRPC.
Sanction is not there in this case?
No, there is no sanction. Without sanction, that the learned court will has taken cognizance.
You're Mr. FZ Mazumdar?
FZ Mazumdar.
Anything from, I will not dispose of today.
Yes,
Record
I
is
have not gone through the records, my lord.
records have come?
Records received because today matter is listed for order.
Orders, record.
If the interim prayer may be considered, if there is nothing, then perhaps I am entitled for interim protection.
Second paragraph, did you have a full stop? The Mr. Mazumdar, Learned Counsel brings to the notice of this court the earlier order dated, observation in the earlier order dated 28/7/26, that after receipt of the records, the prayer for interim IOF stay of the proceedings will be taken up for consideration. The next paragraph, the learned additional PP prays for fixing the matter in the admission column. It has not yet been admitted, right?
Yes.
The prayer is allowed. The matter will be taken up in the admission column on the next day. Next paragraph. The petitioner is seeking, as mentioned above, the petitioner, the criminal proceeding is under 153A 295A IPC. Full stop. The Learned Counsel has drawn attention to section 196 of the CRPC as it existed then. There will be a corresponding section which required, this has not undergone change in BNSS. This is same. This requirement of sanction for this offense has not undergone change.
I'm not sure.
Not sure. But there will be a corresponding section here.
Yes.
Then we'll have to check up this. Can you, to save time, can you help me please? Just you check what is the equivalent of
196.
295A, you check, I will check the BNSS provision. I think this is not changed. But still, we should be sure.
831 of the eight 294.
196.
217.
Nine six is 217 BNSS. 17 of BNSS.
Difficult to remember sometimes. What is the equivalent section of 295A?
331.
331.
Yes.
It is not here. 331. Are you taking the taxman's one? Taxman.
Yes. Yes, taxman.
No, it is different. No, 331 is different. No, 331 is different.
331 is different. Otherwise, 217 is related with 196, the prosecution for offenses against state and for criminal conspiracy to commit such offenses.
299. 299. 295 is now 299. Section 196 of CRPC, presently section 217
217. Yes.
of the BNSS requires prosecution's sanction of the
Yes.
central or state government, as the case may be, for taking cognizance of an offense under section 299 of the BNS. Some submission, the submission is available. It is submitted that therefore, as the sanction, as the cognizance was taken without such sanction, the proceedings are liable to be quashed. The merit of the contention would be looked into in detail at the time of final adjudication. However, it is directed at this stage that further proceedings in PRC number 1111 Saita 24 pending before learned GMFC Dhubri shall remain state till the next date of listing. Okay, remain state. List on, take the date.
Well, 13th of October.
The scan TCR is available.
13th of October.
October. Do it in September only.
September, then on my left, 28th.
All right. Yes, madam.
The Lord, kindly take up the revision first, my lord. Here, my lord,
I is for what?
IA, my lord, an interim order was passed in the revision petition, my lord. And the petitioner submitted the order with a prayer to pay her arrear, my lord, maintenance. Since the honorable court by interim order stayed the impugned order. But that has not been done, my lord. And another order was passed in the IA. Your lordship, I have annexed, my lord, in the IA. At page 17.
I'll take up the I.
First, my lord, your lordship may take up the main.
I'm on the revision only.
Yes, my lord. First, your lordship, the petitioner has initially filed a case under section 125 for maintenance, my lord. So in that case, my lord, as per judgment dated 11/5/2017, a direction was given to pay maintenance to her 5,000 for the petitioner and 3,000 for the minor son, my lord. Subsequently, my lord, the respondent furnished one RTI report stating that the petitioner is and was serving as an assistant teacher. So, my lord, on the basis of that, my lord, without hearing the petitioner, an impugned order was passed, whereby the arrear maintenance was stopped, my lord, kept in abeyance. Because earlier, my lord, after the judgment, the respondent was paying the maintenance regularly till December 2023. From January 2023, he suddenly stopped paying the maintenance, my lord. So, my lord, the petitioner filed one application for payment of arrear maintenance, my lord. That was stopped, my lord. That order is at page annexure D, page 30, my lord, of the revision petition, my lord. Thirty 31.
This was enhancement.
Enhancement, my lord.
Pay maintenance of 5,000 to petition, 3,000 to minor son. Okay.
Here, my lord, it was stopped, kept in abeyance on the ground that she is holding a government service.
In the revision.
In the revision. Whereas, my lord, she is, my lord, doing a job, my lord, which is a temporary job, my lord, contractual, my lord. So, my lord, the petitioner has challenged it by filing this revision petition. This order of, whereby the area maintenance was kept in abeyance.
By
my
that
lord.
court below.
By, my lord, yes, my lord.
By the court below.
This she has challenged before this honorable court, my lord. And by this honorable court, by order dated 6/5/2024, that is annexure 1 of the IA, my lord.
It is the 6/5/24, first order. Till the returnable that the impugn order passed in so and so shall remain state.
Yes, my lord. So, my lord, after obtaining certified copy, she
The direction to put on hold the arrears was stayed.
Yes,
That
my
means he
lord.
is entitled to receive the arrears now.
Yes, my lord.
Okay, so
That has not been paid, my lord, and this order was, another order was passed, page 17, my lord, of the IA.
page 17.
Page 17. Last page, my lord. Peruse the order by which the High Court has stayed the impugn order dated 15/2/2024 passed in so and so. However, no direction has been given by the Honorable High Court to furnish the area maintenance. Hence, the petition dated so and so shall be considered only after receipt of the updated order of the Honorable High Court. So this, my lord, area maintenance has not been paid to her, my lord. In spite of this interim
What
order.
is the prayer in the IA to
IA is to pay her area maintenance because the, my lord,
Order is
impugn
stayed.
order has already been stayed. my
Stayed,
lord.
that's it.
Yes, my lord.
yes, you are paying for the
I'm pairing for
husband?
on behalf of NK Kolitas, Lordship. We have not filed objection till date as we could not obtain the instruction.
2024 matter, my lord.
Yeah, it has come up after. Can we give them a week's time? Okay. Clarify because this order gets stayed. Because this actually, I think this matter needs to be disposed of only,
Yes,
if
ma'am.
possible. Take care of it and dispose it of. Anyway, so you file your reply and we should try to dispose of the matter. Because see, this stay is there. In terms of the stay, she gets the arrears. Arrears maintenance, right? So the whole revision is about staying the arrears. So if she gets the arrears, it amounts to getting the main relief, isn't it?
Yes, ma'am.
So therefore, it should be so Mr. Chaudhary, SB Chaudhary, learned counsel for the petitioner. Your good name, please.
M. Teronpi.
Learned counsel for the respondent. Stop. By order dated 6/5/24, the impugn order dated 15/2024, passed by learned SDGM Bozali, SDGM S. Bozali, in MR 37/26 was stayed. Full stop. The petitioner contends that in view of such stay, she should be entitled to receive the arrears amount, which however was refused by the learned court below by the order dated 13/5/2024 on the ground that no direction, while staying the order, no direction has been given by this court to furnish the arrears maintenance as well. Full stop. Therefore, perhaps the learned court below was looking for some clarity on the matter. The learned counsel for the respondent seeks some time to file a reply. Earlier also, this is actually not justified. Okay, you take 1 week time, but on 25/6/24 also there was a prayer to seeking some time to file objection. 2 years, it should not remain pending for 2 years. That's our fault. So prayer is allowed. However, the respondent side shall take instructions and file pleading, if any, within the on or before the next date. Full stop. Considering the nature of the matter, perhaps an endeavor can be made to dispose of the entire matter altogether. Any records received or records not necessary? Records will. We've lost a lot of time. We could have called for records. We call for the records. Will it be necessary? You cannot say now, actually. In the meantime, call for the scan TCR of MR case number so and so forth. Bojali, it will come. Is from the court of the learned SDZM Bojali. Please take a suggested date, madam.
Date, my lord. Fifteenth of September, my lord.
Okay, 15. Okay, 15. Just 2 minutes. I'll take a break. There's a meeting, so I have to rise latest by 4:30. Okay, so what can be done? Huh? Let's go by your priority or request or whatever. Sir has been appearing earlier also matter did not reach. So your matter is there. 18.
27, 30.
Your 30.
27.
Yeah, morning you made upgradation because
I have made a.
you made an upgrade.
Well, I took 20, my lord. On last 2 occasions also it did not reach. And there is no stay also. And the next date before the learned trial court is in the first week.
Is the problem actually the bail benches, they should be separate bench actually for
Yes,
criminal revision and criminal
Otherwise,
petition.
admission matters are not
No,
getting.
criminal revision and criminal petition I've seen. I'm convinced it needs to be segregated from bail.
Earlier the bench.
No, it needs to be segregated. And criminal appeals, though it's, and you had a prayer for criminal appeal, no? The hearing, Mr. Hoff. No. I had just seen the file in the evening. What is the urgency? It's a 7 years conviction, right?
Lordship, yeah, case lordship last Monday was not listed.
No, you are you want to do the criminal appeal or the IA?
Lordship. I am lordship here in this case. It is a lordship. I am not taking so much time. Lordship, within 10.
Just hold on. Just what to do then? You have to guide me. Then what to do? Which one to take?
Item 30 level adjournment, I pay for adjournment. 30.
I allowed, I think.
30.
Mhm. I allowed you adjournment. No,
Allow.
no. You prayed for adjournment.
Now I pay for.
So now you pray. No, I don't refuse adjournment usually. No.
Can it be 2 lordship? 2nd of September lordship.
Take it after that, next week. Next week is very short.
Then
There'll be, it may
week
not reach also.
next
So
week and
you never know how many matters will come. Take it on 8. Huh? Adjourn, paucity of time. Adjourn, 30 is adjourn. Okay.
7 on this. All issue lordship.
Huh? 8.
Complainant matter. Others can take.
20.
20, my lord. Already there is a settlement has been reached on the basis of the settlement only for crossing.
Just a minute. 22, 23 and 20, you're for 27.
Yes, sir.
22 and 23, if there's no urgency, you take adjournment. Huh? Take an adjournment. Paucity of time, Mr. Atia. Take an adjournment. He'll give you that date. Court master will give you a comfortable date. So
9 also may.
29 also is John. Take a date, huh? Divorce. Yes. Date. Right.
Eight. 18.
Now, 18, 20 and 27. How to take? All 3 may not be possible, but search matter is part hard.
18 may be taken first.
I don't know how long it will take.
Will not take much time.
Consider this year lordship. So we need time. Lordship here
informant is there, Lordship, and Lordship, in what happened in this case?
Just a minute, just a minute. You just work it out. I'll hear this. Yes. You have submitted, no? Almost.
Last occasion I have submitted to some extent, Lordship.
Interim compensation.
Interim compensation. Page 30 is the impugn order.
What was the judgment? Rakesh
Ranjan.
Rakesh Ranjan. No?
Yes, the Honorable Supreme Court has laid down some parameters for considering the application under Section 143 of the NI Act, Lordship. There, in this case, Lordship, the complainant filed a complaint under Section 138 of the NI Act, Lordship, for dishonor object of rupees 10 lakhs, Lordship. And during the accused APR, Lordship, the accused petitioner, and during the pendency of this proceeding, Lordship, they filed another application for interim compensation, Lordship. In the said case, Lordship, this impugn order was passed, page 30. 1 lakh has been allowed. If your Lordship go through the order passed by the trial court, Lordship, this is a very cryptic order without any discussion, Lordship.
Son, Rakesh Ranjan.
And the judgment which I had placed on the last occasion, Lordship, the Honorable Supreme Court has laid down some parameter to consider the application, Lordship. Page 27 of the judgment, Lordship, your Lordship will find parameters laid down by the Honorable Supreme Court. The prima facie case of both the side, Lordship, must be evaluated before passing any order, Lordship. Here only the learned trial court only considered the case of the complainant, Lordship, without discussing the case of the Lordship, the accused petitioner here. Page 20, paragraph 27.
Page?
Paragraph 27. Your Lordship is fine.
Yes, I found.
Got it?
No, I was seeing from this. Same judgment.
Last time I have just.
Yes, I remember now.
Yes. The Lordship has got it. That paragraph 20.
Let's see the impugn order once.
Yes, certainly. On that day also, let's say complainant was also absent and the accused was also absent, but in their absence, Lordship, this order was passed. There is the date fixed for passing of order on petition number so and so filed by the petitioner complainant under Section 143A NI Act. Praying before this court to direct the accused person to pay interim compensation to the complainant at 20% of the total check amount which comes to.
You're right, actually. This in terms of this, the other side has not been discussed actually. The court might have seen the materials, but
Yes, we have
it is not reflected in the order.
Yes, plausible defense we have also.
Not reflected in the order.
We have filed the objection in against the death petition also, Lordship, 140. That was not taken into consideration.
The proceeding is continuing.
Yes.
It stopped. Stopped there in it. No. Yes.
There's an interim order. No,
Interim
interim order is about the interim compensation.
Yeah.
The proceeding is continuing, I think.
It is not continuing now.
The NI proceeding is not continuing.
Not continuing.
If
This one.
there is a no direction.
NI 45 of 23.
Yes,
Then the learned court below has misconstrued or has misunderstood.
This court has only stated the impugn.
Interim,
Yes.
Interim, that has been
But
stated.
proceeding is going on.
Proceeding should go on.
Yes.
That has been understood like that, then it's a big loss for you. Operation of the order has remained suspended. The proceeding should go on. You are not challenging the proceeding. You are challenging
No,
the
I'm
interim
not
order.
challenging the proceeding.
Interim order.
I am only confined to this order only.
Okay, this is your contention basically. Your submission, sir.
Your Lordship, the contention, they are objecting mainly on two grounds, mainly.
Yes.
They are in the plaint, they have two different versions of how this. They are saying that the check was forcibly obtained.
Mhm.
Two versions are there in their state.
Mhm.
First is that in their plaint they say in page number 4 on 21/4/23 at 11 a.m., the complainant along with the hooligans took the petitioner from his home forcefully with the help of police and obtained his signature upon 3 numbers of checks and 2 numbers of blank stamp papers. This is they are saying in page number 4.
Para 3.
And then in their complaint with Nogong court, they are writing on 21/4/23 at 11 a.m. 11 p.m., the complainant along with some other persons took the accused from his home forcefully with the help of Hojai police and obtained his check signature upon the 3 numbers of checks upon 2 blank stamp papers by coercion. They are also mentioning that when the respondent approached police, the police called both the parties and they said that police advised them to settle the matter amicably and they both went home. They both went home and afterwards, how come at 11 p.m., that is 53 kilometers away from Hojai, 53 kilometers, 11 a.m. after the police has said that you close the matter amicably. After that, how come the respondent go to his place at night 11 a.m.? This is one point. Another point they have said that in the complaint of the respondent, page number 10 of it is written that the accused persons had taken advance of rupees 10 lakhs total only from the complainant in the month of November 22. This they are harping on this point. They have not referred to, this is in paragraph 3. They have not referred to paragraph 4 and 5. What it says in the paragraph 4? The complainant also agreed with the accused proposal on 11/4/22 pay a sum of rupees 5 lakhs to accused as an advance token money. And as such, an agreement also executed between the complainant and the accused person by this and not republic. After just receiving that money from the complainant, accused person assured him that shortly he will provide 120 laborers in complainant's big factory. That is 4. On that day, on 11/4/22, they have taken 5 lakhs. Another, on paragraph 5 says that after few, that is page number 12, that after few days of elapsed, accused person again approached the complainant to pay another 5 lakhs as accused faces problems to collect arranged laborers from different sources. And due to complainant urgency, he again paid rupees 5 lakhs. This is the total 10 lakhs rupees what the respondents have paid to the petitioner. And that is what actually this accused person has taken advance of 10 lakhs in the month of November and subsequent. That means age of November 20, this 20 only 10 lakhs was taken, and for which he issued a check 10 lakhs. No coercion was there for him to pay. Now the point is, it's your lordship, that when the case was lodged, it took them 8 months after lodging of the case to file a case in Nogong court. Then after 8 days of their appearance in the court, they did not appear after up to 8 months. They did not appear. Only after this bailable warrant was issued, they came and they sought bail and they got it. After 8 days of getting the bail, they filed that case in Nogam. Only to take care of this, only to hoodwink the this judicial jurisdictions.
All right.
They have no case against the complainant. I mean the respondent.
Okay.
It is admitted position that the checks BS the petitioner signature. Consequently, the statutory presumption under section 118 and 939 of the NI Act immediately comes into operation. The burden was upon the petitioner to rebut this presumption by leading probable evidence. Mere allegations or expressions are insufficient in law. One lakh compensation, they have already taken one year of the same. 1 year they are enjoying, not without paying. That 1 lakh compensation against the request of 2 lakhs, that 1 lakh, it is after all, it is to be, it will be recovered. If the court case there goes against them, they will get back the money. Goes against them, they will have to pay another 9 lakhs. And if they'll, the complainant loses the case, they will get full refund of 1 lakh rupees.
This much on.
The
Any reply?
objection we have filed against the Lordship, your Lordship will find is at page
I've seen.
26. File the objection, Lordship, against the petition under section 143A, Lordship. Here we have pointed out, Lordship, that the amount which they have claimed, Lordship, that is itself contradictory, because the agreement which they have referred in the complaint petition, Lordship, and the statement made in the complaint and the statement made in the agreement are contradictory, because in complaint petition they stated that the dishonour of check of rupees 10 lakhs, referring a agreement, Lordship. In the agreement which they have also annexed with the complaint petition, Lordship, in the agreement it is a categorically, there is a Lordship condition statement that we have rupees 15 lakhs, Lordship. And they filed the case for dishonour of check rupees 10 lakhs, Lordship. And we have already, Lordship, the petitioner have already by filing objection pointed out these things to the learned trial court. But while passing this, Lordship, impugn order, those things have not been, Lordship, considered. And as I had already.
That is your main contention.
Yes, Lordship. I have already, Lordship, submitted the judgment of the Honorable Appeals Court, which also says that if the defense raised by the Lordship, the complainant petitioner is a plausive, the accused, that should be taken into consideration before considering a petition. Because if your Lordship go through the impugn order, that is totally without it passing, without any discussion, Lordship, from our part, Lordship. There was a, Lordship, business transaction between the complainant and the respondent, Lordship. And in pursuance to that, the accused, Lordship, the petitioner here, supposed to supply laborer to the Lordship, the respondent. Lordship, they supplied, but he refused. He take 45 laborers, Lordship, and return back 35 laborers. There was an agreement. There was a business transaction, and in pursuance to which the accused supposed to supply laborer to the Lordship respondent. But the respondent had already paid the amount to the Lordship, the person which they had hired for the respondent, Lordship. Because these are the things, the merit on the merit of the complaint, Lordship. I am only on the Lordship impugn order. Your Lordship is to see whether this order suffers from any illegality. And and if you go through the judgment passed by the Honorable Apex Court, Lordship, this order is illegal, Lordship.
I'll see that aspect.
Yes.
Okay.
Your Lordship, what is why Learned Fairness told? The main problem arose there. He took the money, but he did not supply. And when he's telling about supply, he supplied laborers. They were all, I mean, underage. I mean, not even measured. They were not even adult. They were all child laborers. It just that would have brought the provisions of another act, child labor, against a brickfield owner. So that's why he had no go but to refuse them.
Yes, another point is that Lordship, we categorically denied that we had issued any check because it was obtained by fraud, and we had lodged a complaint also against the Lordship, the respondent. Going on, Lordship, those things should have been Lordship considered before passing this order. This objection part, this should have been considered, Lordship. But the impugn order was passed, Lordship, on the considering the case of the respondent also. There is no. This order is, Lordship, illegal and liable to be set aside.
Lordship, to this I will answer that if I can understand him when he says that, okay, they were forcibly taken. What they did for 8 months, why didn't they go to the to lodge the FIR against?
Those have to be looked into at the stage of trial.
Done by the opposite
Only
party.
prima facie case we'll have to see at this stage. Anyway, I've understood. Reserve. I'll pass the order. Arguments concluded, judgment reserved.
Obliged.
Other matters, I think there will be no time because I have to, because there's a meeting 4:45 where I also have to be there. Kindly take a date, yeah, your case settlement has been arrived at.
Yes, my page
And
30.
you want to quash it.
Yes, ma'am.
Okay, and your matter, Mr. Sharma?
My matter is because Lordship, I'm a complainant. My gold is due to gold, Lordship. Gold is being seized, Lordship, and police has search sheet is being done. But my lower trial court refused to give the Jimma, Lordship.
Of the gold.
Gold.
Gold. You are the informant.
I'm the informant. My contention is that giving the gold, the trial court has opined that it is not known whose gold it is. By this way, accused will be benefited. That observation, Lordship. So my contention is that there is Supreme Court judgment also. It is very specific of the 2022, that is.
That has to be seen. History matters, kindly you have to give a date. Not next week. Next week, don't take next week. Thereafter, you take a date. 23 matter, this can be. Just write an order in 20, item 20. Stop. Mr. Jalan, learned counsel for the petitioner, submits that the petitioners and the private respondent have arrived at the settlement, right? Arrived at the settlement, comma, in the context of which the petitioners are seeking quashing of the criminal proceedings, full stop. The scanned TCR is also available, full stop. The matter could not be heard today due to paucity of time, full stop. List on. It's a 23 matter. We can, on a hearing day, we can fix it at 2 also if you want. 23 matters there.
Yes, my lord. Then it may be on 10th, my lord.
Okay, 10.
At 2.
10th, preferably the matter would be taken up preferably at 2 p.m.
Most obliged, my lord.
Preferably at 2. 20 and then 27. Your matter also take a date. Huh?
Same that 10 September, Lordship, in that case.
So, can you suggest a date, please?
10 September, it's okay, Lordship.
The earlier date to control. And take another date. Take another date. Take it on 15. Huh? 15/9. Paucity of time, 15/9. So.
In the morning, upgradation, if Lordship allows.
On that day, yes. Very difficult, actually. We will continue to face this problem. We should segregate. We should give a proposal from bar. Bail, and then other matters. Not criminal appeal, not bail. The other matters in between.
There were some
orders, revision, everything should come in between.
Otherwise, some appeal matters will never be ended.
We should have this. Three categories: I appeal bench, revision, criminal, IA, everything, one bench, and bail. And only.
That is declared.
Raise accordingly.
You can give a suggestion. We can also suggest, but if it comes from the bar, it's very good. So criminal appeal, IA, you take a date where the IA can be heard.
With hold hand, Lordship, I'm praying on Monday. As because Lordship, in the from the beginning when I filed Lordship this IA along with all the evidences, I am trying to impress to the court to at least see my IA whether acquittal chance of the acquittal is there or not, but not a see.
It doesn't reach.
Lordship, even Lordship.
Monday.
So my Lordship, my with full hand, Lordship, I am now Lordship.
No, don't be with fallen hands. Every person has a right for his matter to be heard. It's not a favor. It's your right. We have to.
I have seen Lordship.
Change the system, improve the system, of course, with limited resources. How about taking it on the week from 7th or on 15th? On 15th. On 15th.
Lordship, it is too long, Lordship.
Hearing matter.
Lordship, what if Lordship is when it come in the motion, then you can say it is not correct. When it is coming in the order, then it is saying
it's coming. You make a otherwise you make a mention for the IA. It will come in orders.
Lordship, there is an order is there. Lordship, that's why Lordship it's hearing come in hearing, Lordship. Though in the last occasions.
IA to like.
Every occasion time বিচাৰি থাকে
আমি এটা মিছৰা নাই এতিয়া তুমি কি কথা কৈছা মই এটা মিছাৰিছো নেকি
Lordship, in other courts, our courts are far better, Lordship. I have been to Allahabad High Court. Even new matters cannot reach for 3 months. Our High Court is far better.
No, still.
I could not. The matter could not be listed for 3 months, Lordship. Matter does not reach. We went there for 5-7 times, Lordship.
My IA just আরে IA এর কথা কইছো আপনি যদি এভরি অকেশন
ভাই দিন টাইম দোনা তোমার কইছো সোয়া কইছো
আজকে অকেশন
Over there. 4 is in 15 of
You want it on Monday?
possible.
Okay. Only IA to the person order. Only IA. Full stop. The learned counsel, Mr. Hawk, submits that on several dates the matter has come up, but has not reached due to paucity of, could not be taken up due to paucity of time. And it is submitted that he desires to address the court on the prayer for suspension of sentence and bail. Full stop. And 6 an early hearing for the same. Monday actually would be some time constraint.
Then Lordship
Can be on the next week.
Lordship is possible 9, 8 or 9 Lordship 9.
List the matter in the orders column on 9.
9. High levels.
If necessary, you make a mention in the morning.
Lordship.
And there should be another thing. See, there's nowadays so much technology is available. AI is also available. There should be a method that matter which does not reach today is listed automatically tomorrow or day after tomorrow.
Lordship.
Up the list.
Lordship.
So matter which does not reach today will be heard on Wednesday. And if not on Wednesday, then definitely on Friday. That means once a matter gets listed, it comes before the court in a guaranteed manner.
Lordship.
If not today, then tomorrow, then day after, automatically, without your doing mention, without doing anything. And this can be easily done. Algorithm, you just have to make it. Technologically, it can be automatically done. So we have to work together to do these things for the benefit of ultimately it's litigants, right? Why should your matter not be heard? That's not a favor. That's your right.